2022. Its third court motions before the Honorable Justices Musimang, Lukaimani, and Leroux. Calling today's matter, it's case number 511159 of 21. It's the matter of ETV versus the Minister of Communications and Digital Technologies and others. Council, kindly take note that these proceedings are being recorded and that no private recordings will be permitted. Council that is addressing the judge must unmute themselves, and those that are not addressing the judge must just remain muted. Thank you.
May it please the court, I appear for the applicants, ETV, together with my learned friends, Mr. Du Plessis, Mr. Khumbudzo, Ms. Padafin-Jones, and Ms. Moody.
Thank you, Mr. Marcus.
May it please the court, I appear on behalf of the applicants for intervention together with Ms. Kachaya. It's Mr. Ferreira.
Thank you, Mr. Ferreira.
May it please the court, together with my learned friends, Mr. Makula, Ms. Lekopotla, Mr. Smith, and Ms. Ntshvheni, I appear for the Minister.
Thank you, Mr. Mutawu.
As it pleases the court, my name is William Mukari. I appear with my juniors, Mr. Makatu and Ms. Litole, for the second and third respondent.
Thank you, Mr. Mukari.
May it please the court, Frank Snickers, appearing with my learned friends Mr. Turner and Ms. Musimang for Vodacom, the sixth respondent.
Thank you, Mr. Snickers. Thanks, Council, for having placed yourself on record. In this matter, I and my sisters put our heads together as to exactly how we want the proceedings to go on. There's possibility of arranging for allocation of times. There's something in the background there. Do you hear it? There's somebody who's got some noise in the background. Can you please make sure that that noise, because we get an echo. Thank you. So we're discussing whether we should allocate council slots as to how long you should speak, because we've got 2 days and we must make sure that these proceedings are held and finalized within the 2 days. And we also decided that maybe it's not the best way to allocate time slots, but rather to make sure that, as we have read, everybody has read the papers, council should be permitted to address the court, but only on issues that are pertinent to this matter. We have read the papers. We don't expect council to take us back to all the 4,000 pages of notes or documents that have been filed. But what are the issues? It's unfortunate that we did not have the opportunity or the occasion to speak to council before in chambers. You know, there's those talks that we have in chambers, so that we should be able to delineate the issues and say what are the issues. But this is how we propose, but still, maybe council, because I'm all going to give you an opportunity to address on how the proceedings should go forward. Basically, what I want us to look at is what are the important issues that we should discuss. We know, for example, the notes I've made for myself. I've got lots of questions to ask, but I think the most important issues which I also expect, particularly counsel for the applicant, in the issue of what I've marked here for my own, I always make my own notes as clearing the runaway. Clearing the runaway, we can have two flights sharing the runway at the same time. When they take off or land, the runaway must be clear. So the spectrum, IMT 700 and IMT 800, it looks from the papers that everyone agrees that this spectrum has been allocated for mobile telephony, and that as long as there is analog there's going to be interference, and the best thing is that there should not be any analog broadcasting. As a result, I want to have everybody found common cause with the fact that if that spectrum is made available, it must be clear of any analog transmissions. That's what I would have asked the first question. The next question that I would have asked is this argument, which I've dubbed on my notes, the rich versus the poor. This ETV says no. The mobile operators just want this thing. The minister and the mobile operators want this thing rushed because the mobile operators tend to benefit from the release of the spectrum. And the mobile operators, on the other hand, judging from Vodacom's response, that no, there's nothing about really being for the poor. The main thing is ETV wants to cling on to the spectrum for as long as possible. So that argument, whether it is the interest, that argument, rich, as I say, the rich versus the poor, is that the clearing of the spectrum and the continued broadcasting on that spectrum. So that argument is there as to it. And the last one of my own notes is that these are critical issues, is what I've termed Skimbo shams. There's a poem that there's a school of the railway cat, Skimbo shams, that unless he's very nimble, then the train can't start. That argument is the delayed migration. The argument is should analog stay there, or should there be not a switch off? Switch off should not take place until such time that all analog TVs have been given set boxes, or have probably by the time, because these are old TVs, if they break, I suppose, they won't be repaired anyway. So the clear in that thing, do we say, is that the argument that all analog TVs must be given set boxes before there is a switch off? As I say, I'm trying to say, if we were to say what are the issues that we have to discuss, and these for me are the ones that there are many other issues, and my sisters probably would also want to set up the issues, to say what issues they want to be ventilated. But that's our take, that we should. Are we in a position to say what are the main issues that have to be discussed? And are we saying it is common cause that the IMG 700 and 800 spectrum has to be cleared. The runway has to be clean, and analog TV must be switched off. That's how I see the issues. Maybe I should invite counsel and see if you are able to agree with us, or you want to place more issues as critical. Because if we are able to say these are critical issues, then we address those issues, then we'll be able to finalize this matter, hopefully today, and if not, we'll have another tomorrow as a fallback position. Can I hear counsel? Or do my sisters want to add anything to what I've said?
I think I would want to wait for counsel to hear what they identify as important issues, and then when they are done, if they've left out anything that's on my list, then I will raise those issues.
Thank you.
And I'll do the same. Let's hear from counsel.
Counsel, the court is yours.
Thank you, my lord, and my ladies. My lord and my ladies, I don't for one moment doubt that the three issues which his lordship has identified are indeed issues in these proceedings. We respectfully submit, however, that there are several other critical issues. May I outline what topics I propose to address, and may I also inform the court that I've had a brief chat with my learned friend, Mr. Ferreira, for the interveners in an endeavour to ensure that we do not unnecessarily repeat each other's arguments. With that in mind, let me indicate what I propose to address, and let me give his lordship the assurance that certainly in relation to the second and third issues that he has raised, that those two will be properly addressed and embraced in my address. So I propose to address 5 topics. The first, which is really a framework argument, is I will deal with the state's constitutional duties in the context of this case. Second, I will address the state's public promises relating to digital migration, and particularly its repeated undertakings to provide set-top boxes to those who can't afford them, and we will, under this topic, deal with the breach of those promises. Thirdly, we will deal with the state's unjustified violation of the rights to freedom of expression and its associated rights. Fourth, we will deal with the minister's obligation to consult interested and affected parties about access to set-top boxes and the date for the analog switch-off, and we will address the breach of those obligations. And fifth and lastly, we will deal with remedy. As your lordship will see, your second and third questions are most certainly embraced in my second to fifth topics. We have filed full heads of argument. We stand by those heads. We will only refer to them as necessary from time to time. But for purposes of my oral argument, I have prepared a document which captures, I would think, virtually every single reference to the record or the cases upon which we rely. I will refer to that as my references document, and we have had it uploaded on case lines, and it is to be found at 021-312, 021-312, and it runs to 021-326. So may I then begin with the state's duties, because the core question, as we see it, is whether or not the state has complied with those duties. And if
Mr. Marcus, maybe now that you've outlined what you are going to say, maybe let's hear the other council as well to outline what is it that they are going to be present, because when we know who is going to say what, we'll be able to determine how this proceeding should go on. Can I hear Mr. Now that you've spoken, I imagine you've spoken for both yourself and the interveners.
I don't want to claim to have spoken for them, my lord, merely to say that I did have a discussion with him beforehand to inform them of what I propose to address, but I cannot say what he will address. I only say that we will endeavour to avoid duplication.
Maybe then what we should do, we should let you go. Let you go, and because I would have thought if every council at this stage indicated what is it that we are going to say, at least we have some direction as to where this matter is going.
Yes. And so Mr. Ferreira must proceed to say what he's going to address.
Thank you, Mr. Ferreira.
Thank you, my lord, my ladies. As Mr. Marcus indicated, we will not duplicate any of one another's submissions. The issues which I propose to address are firstly the intervention application. It's not clear to me whether any of the respondents persists in opposing that application. I'll hear from them when they lay out what they wish to address. It may not be necessary for me to address that issue depending on whether they persist in the opposition. Secondly, some brief issues concerning the facts, the critical facts, in particular in relation to the consequences of the selection of the date of analog switch-off for how many people will lose access to free-to-air television and for how long will they lose that access. And that factual issue requires a fair bit of examination on the pleadings. Thirdly, the review of the determination of analog switch-off date, and in particular from our side a focus on the rationality of that decision. Fourthly, the defences which have been put up to that review, both by the state and then by Vodacom, and then some very brief submissions on the remainder of the relief in relation to the declaratory relief and the reporting relief. And I should just say, in terms of time, I don't think I will need much longer than an hour to 15 minutes, depending on how many interventions there are from the bench.
Thank you, Mr. Ferreira. Can you then hear from...
Maybe before we hear from the next council, Mr. Marcus can just give us an indication, like Mr. Ferreira did, as to how much time he'll need.
Yes, milady. I estimate that I will require probably not more than an hour and 45 minutes. So taken together with my learned friend, Mr. Ferreira, we're probably looking at between 3 and 3¼ hours. That will leave ample time for this matter to be finished in 2 days.
Thank you.
Thank you. Mr. Mutawa.
Thank you, Justices. We intend to cover the topics that are set out in paragraph 16 of our heads of argument.
That is how we on these lines where?
Page 021-227.
Okay, you can proceed.
It's commencing at paragraph 16 to 16.5. And I should also indicate the following points that are not reflected there. We will be covering ETV's obstructive stance to digital migration. also be dealing with the question of public promises, and the inappropriateness of the relief sought. And to this end, one point that requires emphasis is whether a review of the announcement of the ASO is competent on the facts and circumstances of the case, having regard to the fact that that review was foreshadowed as a possible relief that would be sought in the event that the ASO was announced after the finalization of the pleadings but prior to the matter being heard. And there the point will be whether is it competent in the absence of the minister having been squarely challenged and no reasons having been put up for that decision. My estimated timeline is more or less similar to that of Mr. Marcus, subject to the questions that the court will be asking. Thank you, Justices.
Thank you.
Thank you, Mr. Mutau. Mr. Mukari.
Thank you, my lord. Well, insofar as ICASA is concerned, you'll have seen that our attack is quite narrow in the sense that we assert that there is no legal justification in the papers as they stand for any relief against ICASA. So we're going to really
am I the only one having a problem with the audio?
No, I've lost him as well.
We lost Mr. Mukari. I don't know what's happening. Mr. Mukari? We can see his office there.
Yeah, it seems to be frozen.
Perhaps we'll go to Mr. Snickers and Mr. Makari, I assume, will reconnect.
Yes.
Are the other counsel still there?
Yes, Advocate Snickers.
We are, my lord.
Oh, then what do we do? Let's see, maybe we should give him...
Should I try and get hold of Mr. Makori? There he is. Seems like it says he's leaving. Maybe he's come
Yes,
back.
I think he's going to try and reconnect. I think you should proceed in the meantime for Vodacom.
Thank you, my lady.
Okay, Vodacom, Mr. Sniper? No. Mr. Who's next now? Mr. Mukar? Oh, Mr. Snipers, Vodacom, yes.
Thank you, my lord. The three issues identified by your lordship with great respect are very much in point, and those will be issues that Vodacom will be addressing, particularly the second and the third. But Vodacom's main focus, in fact, its full focus in this proceeding will be on the inappropriateness of the interdictory relief, which is your third point in relation to saying that there cannot be digital migration until every last set-top box has been delivered. And the effect of that relief on ICASA's freedom properly to assign spectrum for IMT, and in particular on the threatened and current proceedings that are challenging the auction. So that will be the focus. Vodacom will draw a distinction, a bright distinction, between the review of the date for ASO, which I understand my learned friend Mr. Mortao will address on the extent to which it is before the court and address the defenses on that. So there'll be a distinction drawn between that and the interdictory relief. Vodacom is concerned with the interdictory relief and the effect that that has on the auction and on the assignment of spectrum. And Vodacom will also, and this links to your lordship's second theme of the rich versus the poor, indicate how, not whether, but how the right to freedom of expression is actually at issue in what is at stake here, and that the dichotomy set up by ETV in this regard is entirely false. So those are the main themes that Vodacom will concentrate on.
And Mr. Snickers, how long do you estimate you'll need?
My lady, also depending on interaction, I can't see my address being much more than an hour. What we did do beforehand last week amongst ourselves, the senior council, was we agreed that it seems that ETV and the interveners and the minister and probably some of ICASA will be today, and that we and replies will be tomorrow. So if that more or less is how the time allocation will go, we all think that there'll be a comfortable finishing of the proceedings. So on what we've been told now, the time estimate seems slightly longer than we had thought, which suggests that you'll probably hear ETV, the interveners, and a portion of the minister, or finally the minister today, and then you'll hear.
Well, I lost your sound.
You lost the sound, yes.
Can I be heard?
Yeah, now we are.
Yeah, now we can hear you.
I'm terribly sorry. It looks as though maybe there seem to be 60 people online. That could be a problem. I'm not sure where I got lost. What I was saying was that on the time estimates that we'd heard today, it appears as though one will definitely have ETV, the interveners, and most of the minister finalized today, and that will leave ICASA and Vodacom and the replies, or part of ICASA and Vodacom and the replies, or all of ICASA and Vodacom and replies for tomorrow. So that amongst council, I think, is relatively comfortable. My time on my own, I think, won't exceed an hour, probably shorter than that.
Okay, thanks, Mr. Snickers. Can we check if the other party was up there? Oh,
yes, I'm back now, my lord. I'm sorry. As I was busy addressing the court, the Wi-Fi dropped completely to zero, but I've been able to now use my line to connect, which will be much stable. So I don't know at what point I completely disappeared, but I was simply saying that insofar as the CASA is concerned, we'll be addressing issues that are confined to the regulatory regime within which ICASA operates, and also the significance of ICASA releasing the remaining high demand radio frequency spectrum, which already it has started releasing, and also then to say that if one properly construe the relief sought by an ETV is effectively to interdict the release of the high demand spectrum, especially the 700 and 800 megs, which is already then under the hammer as we speak in an auction. So then that's really what we'll be addressing, to say that the nature of the relief, which is disguised as declaratory orders, but in effect an interdict to the release of the high demand spectrum, should be granted. And other issues that are raised of a legal nature, we make common cause with what the minister has canvassed in both the answering affidavit and the heads of arguments. So I estimate our oral submissions not to be more than 30 minutes. And of course, I agree with Mr. Snickers that we did speak as senior counsel for the respective parties about time allocation, and we did anticipate that today probably then could be allocated to ETV, the intervener, as well as the minister, and ICASA then could probably start tomorrow morning, and Vodacom will still be able to argue, and the reply can still be accommodated for us to finish within the allocated time.
Thank you, Mr. Nkari. Maybe now that we've got an indication, and it appears that council, senior council have met, in fact, and also arranged this for the allocation of time. Maybe we shouldn't waste more time. We should just permit Mr. Marcus
Thank you very much.
Take the podium. Yeah.
Thank you, my lord and my ladies. Let me then immediately commence with my first topic. I had indicated that I commence with this topic because it frames the rest of our argument. And that is the core question in our respectful submission is going to be whether or not the state complied with its constitutional duties. If the answer to that is in the negative, as we submitted clearly is, then the real final debate turns on what the appropriate remedy is for those breaches. I indicated, my ladies and my lord, that I've loaded my references document on case lines. It's at 021-312. It will save your lordship and your ladyships the trouble of taking down all the references. If there is anything that is not in my references document, I will point it out to you. We submit that the state is under 5 duties which are relevant to this case. The first is easy. It is the duty to respect, protect, promote, and fulfill the rights in the Bill of Rights. That is an obligation which flows from Section 7, subsection 2 of the Constitution. You'll find that reference in para 1.1 of our references document. The second duty is equally uncontroversial. It is to observe the basic values and principles governing public administration, and that obligation is enshrined in Section 195 of the Constitution. Relevant to this case are the values and principles which relate to the promotion and maintenance of a high standard of professional ethics. That's in Section 195(1)(a). Responsiveness to people's needs, which is in 195(1)(e). The requirement of accountability, which is in subsection F, and importantly, the fostering of transparency by providing the public with timely, accessible, and accurate information, and that is in section 195(1)(g). A helpful authority on these obligations, and this is to be found in para 1.2 of my references, is the Constitutional Court decision in Van der Merwe versus Taylor at paragraphs 71 to 72, in which the Constitutional Court made the link between section 195 on the one hand and the rule of law enshrined in section 1 on the other. And the court observed at paragraph 72, section 195 reinforces these constitutional ideals. It contemplates a public service in the broader context of transformation as envisaged in the Constitution, and aims to reverse the disregard, disdain, and indignity with which the public in general had been treated by administrators in the past. And I would ask the court to bear those words in mind when I come to deal with the further topics. The third duty, again uncontroversial and one which doesn't require elaboration, is that the Constitutional Court has said on many occasions that the state has a duty to lead by example. We give you references in paragraph 1.3 of my references document. The fourth duty is important in this case. It is the duty of candor in litigation. And we address the authorities in 1.4 of my notes, the first of which is the well-known decision in the Constitutional Court in MEC for Health versus Kurland, in which the court emphasized that there is a higher duty on the state to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. I repeat, to tread respectfully when dealing with rights. And similarly, in the recent decision of the Public Protector and the Reserve Bank, the Constitutional Court specifically endorsed a previous judgment by Justice Sachs in the court, which required the state to be candid in litigation. In that case, the court said the Constitution requires candor on the part of government. What is involved is not simply a matter of showing courtesy to the public and to the courts, desirable though that always is. It is a question of maintaining respect for the constitutional injunction that our democratic government be accountable, responsive, and open. Lastly, on the state's duties, and this is a critical one in the context of this case, is the state's duty to honour undertakings. And that is what we have referred to in our heads as the KwaZulu-Natal principle. I have given you the references in paragraph 1.5 of my references document. There, like the present case, the court was concerned with undertakings or promises that had been made and which were breached, and hence the establishment of the so-called KwaZulu principle. In our heads, and this is important, at paragraph 78 at 021-83, we refer to the follow-up decision in the KZN case, which was the case of Pretorius. And we make the point in paragraph 78 of our heads that the KZN principle has been held to be not based on a breach of the right to just administrative action, but on the far more fundamental misconduct by the state. Now, I emphasize that point because one of the debates that this case throws up is whether or not the minister's decisions are administrative in nature or are executive in nature. If the KZN principle is held to apply, it matters not. That principle applies regardless of whether the action in question is administrative or executive. Now, with those...
Mr. Marcus, you have now mentioned this case that you just mentioned. Can you give us a citation? Because
yes,
in your reference,
yeah,
it doesn't appear.
My lord, I have given you the references in my reference document to our heads of argument at paragraphs 72 to 84, where we address the KZN principle in great detail. But if you want the reference to the case, it's 2013, volume 4 of the South African Law Reports, page 262, Constitutional Court, but it is addressed in detail in our heads of argument at the place that I have given you in my references document. So, my lord and my ladies, that frames the arguments which I now address, and I move to my second topic, which are the promises made and unfulfilled. And the court will see immediately that if I'm correct, that promises were indeed made and were unfulfilled, then the KZN principle is immediately engaged. But let me address the court first on the facts. In our heads, we detail the public promises made by the state that, having regard to the fact that many millions of South Africans cannot afford to migrate to digital, set-top boxes will be provided to them. Those promises were repeated, those promises were unequivocal, and they form the bedrock of the state's commitment to ensure that all South Africans have access to public broadcasting services regardless of economic status. If I may pause there, and I'm going to take the court to some of those promises. This addresses squarely Justice Msimang's second point about the divide between rich and poor. The commitment was first made in the 2008 digital migration policy. We set out the nature of those promises in our heads, and you will find the references in 2.1 of my references document, where we quote from the 2008 digital migration policy. May I just highlight in particular what is said in paragraph 30 of our heads of argument, where we set out what the migration policy contains. And in 2.1.4 of that policy, it says government has decided as a matter of policy to consider finding means of making the STBs affordable and available to the poorest TV-owning households. This support by government should be seen as part of its commitment to bridging the digital divide in South Africa. Accordingly, for South Africa, the STBs will have special features which enable access to government services for all citizens, especially those who thus far have had limited or no access. It goes on to say digital broadcasting also enables the provision of services in a multiplicity of languages, thus increasing access to information, which, in line with government's information society vision, is an important tool for societal and economic development. And then critically, this is essential to meet our poverty reduction goals. We detail further in our heads the pronouncements from the 2012 amendment to the digital migration policy. We address that in paragraph 32 of our heads, and likewise we deal with the 2015 amendment to the migration policy, which we address in paragraph 35 of our heads. And perhaps I could just take you there. Again, it is in my notes. It's in paragraph 2.3. But in paragraph 35, we quote from the 2015 amendment to the digital migration policy, and that amendment records as follows: in order for households to continue to receive television services on their current analog TV sets after the analog signal is switched off, set-top boxes which convert the digital signals into analog signals are required. The total TV-owning households in South Africa are estimated at 13 million, of which approximately 65% rely exclusively on free-to-air broadcasting services. So those promises that I've thus far highlighted are embodied in official policy documents. Did Justice LaRue?
Yes, Mr. Marcus. Just since we're spending the morning making sure that everyone knows what we'd like you to address us on, when you get to your fourth topic about the obligations to consult, could you address us on the effect of the 2015 amendment that withdrew the obligation with respect to broadcasters? So it was the set the date in consultation with Cabinet, and I think the language is affected broadcasters, and then that's deleted in 2015. If you could just put that on your list for your fourth topic, I'm sure it is.
Certainly. So, I've indicated that thus far these promises have been made in official policy documents, but they went further. The promises were also made in public pronouncements. So we refer in this regard to a fact sheet which was put out entitled Broadcasting Digital Migration, which spells this out. We give you the reference in paragraph 2.4 of our reference document. In my reference document, I think I incorrectly indicate that it is Annexure PA 29, but in fact it's Annexure PA 28. The page numbers I give to case lines in my references document are correct. And you will see from that document, and I'm now at the case lines reference, under the heading South Africa's Broadcasting Digital Migration Program, it says there that government is also responsible for ensuring that funding is available for the scheme for ownership support for poor households and for the development of a STB manufacturing strategy. And on the next page, under the heading, and this is on 001-310, under the heading Facts That Affect You, the fourth bullet point, it says the government will provide free STBs to more than 5 million poor household television owners, and the following groups are eligible to receive subsidies, and that it then sets out who is eligible in that regard. So that much once again reiterates the promise that was made. The Minister herself reaffirmed this commitment as recently as the 5th of October last year, and you'll find the reference to that in paragraph 2.5 of my references document. The Minister's public statement, it's entitled Media Statement by the Minister of Communications and Digital Technologies, is Annexure PR 17. It's at 001-214. If I could take you to paragraph 1.3 of this media statement, it says, during the 2021 State of the Nation address, His Excellency President Cyril Ramaphosa announced that South Africa must complete the broadcast digital migration by 31 March 2022. And we do know that now the Minister has in fact gazetted that particular date. In the next paragraph on 001-215, it's paragraph 2.1 of the media statement, it says, the government undertook to assist beneficiary households earning total salary of less than 3,500 Rand per month, with installation of set-top boxes to ensure universal migration. The process of registering beneficiary households to be supported commenced in 2015, and to date 1.184 million qualifying households have been registered out of the estimated 3.75 million qualifying households. And then finally in this media statement by the current Minister, in paragraph 4.1, it is said, to give effect to a successful digital migration and analog switch-off process, we have to ensure that everyone who needs to migrate from analog to digital is ready to do so and are not negatively affected by the switch over to analog, from analog to digital. I would underline those words, not negatively affected by the switch over from analog to digital. The analog switch off messages will scroll on analog TVs with dates. Please ensure that you migrate before those dates. So what we see now is promises made in official documents, promises made in media statements, and in these very proceedings under oath. Those promises are repeated. We give you the references in paragraph 2.7 of our references document, where we reference our own heads of argument at paragraph 40, at 021-65, in which we say, before this court, the Minister repeats these promises. The answering affidavit contains the following undertakings. The first one, quote, government's undertaking to make devices, STBs, available to qualifying households is well documented. It says, government has committed to assist the poorest TV-owning households to obtain STBs to enable them to receive DTT. The Minister and Department intend to ensure that all qualifying households receive STBs. And thirdly, government has not and will not be leaving any South Africans behind. So there we have it on oath in these proceedings as well. And finally in this regard, and we reference this in 2.8 of our references document, we draw attention to the observation by the Constitutional Court in the electronic media network matter, where the court said, and again I quote, set-top boxes will be required for the foreseeable future until television sets with technology to unscramble digital signals are accessible to all. These boxes will thus be needed by the financially under-resourced for as long as television sets with signal unscrambling capabilities are beyond reach. So, the need for access to STBs has been repeatedly promised, and the question that arises is, why did the state make those promises at all? And we submit that the answer is clear. The state made those promises pursuant to its constitutional duties, some of which I've already outlined in my opening chapter. Section 7.2 obliged the state to respect, protect and promote the rights in the Bill of Rights, to ensure that those people who might be cut off were not negatively affected by those cut-offs. And so we submit these promises were made pursuant to a constitutional commitment. It was not an act of kindness or benevolence, it was the fulfillment of a duty. But we submit the haste with which the ASO is now being pursued fundamentally undermines the stated commitment and threatens a breach of constitutional rights on a massive scale. Now, the facts in this regard are stark. We have suggested in our heads of argument, based upon the state's own figures, that some 8 million indigent South Africans are at risk of being left behind. We give you the references in 2.10 of our references document, but my learned friend, Mr. Ferreira, will deal with that in far greater detail. Now,
Mr. Marcus, sorry, just on this, and perhaps in your division of labour it's for Mr. Ferreira, or perhaps in fairness it may be for Mr. Matau. But one difficulty that I think the court has to confront is the facts around who remains that these promises were made to. And I just wanted to get your submissions on this, given that the court is obviously going to have to plask on Evans what's before us. So am I correct that in terms of the facts, we know 1.45 million set-top boxes have been procured. We know that in the papers it's 596,954 are now installed, leaving 671,925 people registered before 31 October who need a set-top box. And we know there are 800,000 boxes in stock somewhere. So what we don't have, and if I read your replying affidavit, para 46, correctly, you said, and it seems to me clear that we don't have before us how many of the 671,000 registered but not installed have been installed by now, and how many of the remaining set-top boxes are available as a result, and how many registrations post 31 October have happened. So I think the difficulty we have potentially is that, you know, the 8 million figure is based on a census extrapolation of the number of people in the average household. We've used similar Stats SA information to say how many households we think would qualify. But am I correct that we don't actually know how many people that were promised a box by shut-off, which is now 31 March, who did what we asked them to do and registered by 31 October? We don't actually know how many of those people we still have as the court hears the case. Is that correct? And we don't know how many other people have registered to date. It may be for Mr. Matau, but I don't know if you could help if we've just missed where we got an update, or if that is the position. And given that we know that the 8 million is an extrapolation and it has its own difficulties, we may be somewhere between 671,000 and 8 million.
Yes. my lady, your ladyship is absolutely correct. And may I make perhaps an initial submission? My learned friend, Mr. Ferreira, will indeed elaborate on the figures and those extrapolations. What is important, and I am coming to it, is that it links into, again, one of the state's duties, and that is the duty of candor in litigation. Because in our replying affidavit, we specifically invited the minister to furnish this information, the very information to which your ladyship refers, and she hasn't done so. And we will submit that is a breach of that duty of candor. But let me make this umbrella submission, if I may, is whatever the exact figure may be, the court can confidently accept that it runs into millions. So the debate about the exact number is in a sense a puerile debate. And it is equally puerile for our learned friends to suggest that we would hold the minister to an undertaking to ensure that every last single eligible household receives a set-top box before she can flip the switch from analog to digital. We don't make a childish argument of that sort. But what we do say, respectfully, is that to the extent that a significant number are left behind, which seems palpably to be the case, then we are in the realm of a constitutional violation on a massive scale.
And Council, that is why the numbers and the progress is important, so that we actually see, so the numbers are not just for us to say where are they sitting now, but it's also for us to be able to say, if we are to grant any relief, what would the extent of that relief be, because looking at the progress that the first respondent has been able to make thus far. So it gives us a sort of reference point to say how long does it take to do certain things.
Once again, I agree. And the
Mr. Martin, before can I just add to that question of my sister? The 3.75 million indigent households that we seem to have identified, I may well have missed it in the 3,000 pages. We don't have any better facts on how many indigent households, i.e. those on less than 3,500 a month. Do we know how many of those actually have TVs? Because obviously there's a group in that 3 odd million that may not have TVs, may already have been able to somehow access digital. Do we know how many TVs there are, rather than how many people live on below 3,500 a month?
My lady, I'll check that. I'm not sure of the answer, but let me do so at the point. I'm not sure when that will be, that we take the tea adjournment, and I will see if I can be of assistance there. But let me answer the previous question. Of course it is essential that the court be given accurate figures. There is only one party who could properly do that, and that is the minister. These are facts which are within the exclusive knowledge of the department. Bear in mind that it is the department and the minister who has made those promises. If those promises were seriously made and intended, as we must accept them to be, then the minister is the one who knows what is required to fulfill those promises. So, as I say, my learned friend Mr. Ferreira will elaborate on that. But for purposes of my argument, all that is necessary is for the court to accept, and it can comfortably and safely accept, that there are millions who are going to be left out, and that threatens a constitutional breach on a massive scale. It squarely engages the KwaZulu-Natal principle which we have addressed, and I've given you the references in 2.11 of my references document. In short, to round off this topic, there has been a series of undertakings. They were seriously made. They were intended to be acted upon. There has been a palpable breach of those undertakings, and we submit that the KZN principle applies squarely, and I repeat, that principle applies irrespective of whether the minister's decisions are administrative or executive in nature. So, if we are...
Sorry, on the KZN principle, I just wanted to get your submission to the proposition that, so if we assume that the court accepts that promises have been made that would fall within the KZN principle, para 52 of that decision, what would your submission be to the proposition that the people to whom those promises were made, i.e., if you register, you will get a set-top box before analog shutoff, that's the 671,000 registered by 31 October, you would accept that that's at least the core of the people to whom the KZN principle promise was made. They did what government asked. They duly registered by the end of, well, the 31 October deadline. I know there can be registration after. But would you agree that that's the heart of the KZN principal group who had a promise made to them? They did what government asked. They went and registered at the post office. We need to know if they got a set-top box before 31 March, if that's when analog shut-off happens. Is that the core of the KZN principal group?
My lady, it certainly is the core. I hesitate to use inappropriate language, but let me use the language that your ladyship has used and accept that they form part of the core of the let me turn it this way, the beneficiaries of that principle. But if you look at the promises that were made, they extended to everyone who couldn't afford a set-top box. And I'm pleased you raised the issue now, because it's going to be part of my fourth topic on the duty of consultation. To the extent that there are potentially millions who are at risk of being cut off, it particularly engages an obligation to consult, to ensure precisely what numbers are affected, what problems there may have been with the registration process, how best to address that problem, and certainly not to do what has occurred in this case, and that is to act precipitously and to switch off at a time when, as an absolute certainty, there are vast numbers of affected households who will be unable to access digital television.
Mr. Marcus,
yes.
Mr. Marcus, isn't the crux of this problem that we have is that all the figures that we are working on are speculative, in a sense that when the promise was made, the ministry was working on statistics from State South Africa. And those statistics, I want us to start there. Those statistics were then compiled specifically for those indigent families that require STD boxes, or were those figures extrapolated from a report from State SA, which spoke generally about indigent persons. That's my first thing, because let me put all this so that we just know here. The second difficulty is that when these policies were made, it was during that period when this migration process started. And the more time is of the efforts, the more there is a delay, the more those figures of 2018, the more the people maybe will acquire more sets. Those people who may have been indigent in that time may no longer be indigent. You know, these are all the things that come up with those statistics, because we're working on statistics which maybe Mr. Mutau is listening, because I want to know were those statistics compiled specifically for the problem that we are facing. Because if they were not specifically for the problem that we are facing, the question is, can we justifiably rely on those figures? Then
No, sorry, apologies for that. I thought you were done. There's something that I need to bring pertinently to the court so that our learned friends can also have an opportunity to address it during their argument. But perhaps let me first wait for Justice Nsimang to finish his questions, and then if I might just be allowed to provide certain information, and perhaps on the basis of that, it will also afford our learned friends an opportunity to address it.
Thanks, Mr. Mutau. You see, and Mr. Marcus, as I say, I don't have, and this court does not have a report, or you know what we can call a medical legal report, that zooms into these questions to say how many households are there, how many people are indigent, how many STBs are required, how many STBs are being provided. You know, we don't have that. All we're having is on figures that, in my view, are speculative, very, very speculative, and you know, it will be difficult for this court to be able to say millions of people, as you put it, will be left without televisions or audio. So, you know, that's where my difficulty comes in. Maybe you should do that. It will give you an opportunity. It will also give your interveners an opportunity also to interrogate them, because do we really have a report that zooms into all these things and tell us what the problem is? Thank you, Mr. Marcus. You can respond. Mr. Mutau wanted to say something. I don't know.
Yes.
Mr. Mutau?
Yes, thank you, Justices. We've been instructed to indicate the following to the court so that our learned friends can also deal with it. The court will require, and we will make our submissions in due course, that the KZN principle applies to the specifically identified group of 672 plus. And in that regard, our instructions are that the minister is tendering that after argument but before judgment is given, to provide an updated figure regarding that affected number to whom the principle applies. And in addition to that, given the fact that the cut-off date of the 31st is the date upon which the court has been requested to deliver its judgment, it is also available to the court if it requires a further report shortly after the 31st, not for purposes of an interdict, but only for purposes of satisfying itself that the minister's commitment has indeed been kept. The minister is also prepared to provide another report shortly thereafter. In other words, your current scenario prior to the giving of judgment and the one shortly thereafter, as the court may wish to direct. But I should be understood so that our learned friends should not confuse perhaps this point. Our point, and we'll address it, the KZN principle we say applies to the criteria, sorry, to the group that has been identified in terms of the policy, and those are the numbers in terms of where we are now, 672,000 plus. Thereabout, and we will illustrate how that promise has been kept.
Mr. Mutau.
Right.
Sorry, so just a little before I step up.
My sister, you wanted to say something?
I think both your sisters want to say something.
Yes.
Okay, go ahead.
You can go ahead.
Well, I'm the most junior. Justice Lukamani, you go.
No, I'm happy. I don't know. Mr. Mutau, now I am sort of thinking, why couldn't the minister have provided all this information ahead of time? Because I'm sure that Mr. Marcus certainly needed those things to sort of finalize his argument, and I would think that now maybe you want to, not after argument, but it might be something that documentation is provided to the court by tomorrow morning when we sit, that you file an affidavit, a supplementary affidavit, sort of indicating all this additional information, because it certainly could have been provided by end of business on Friday, so that everybody is sort of in there. But given that we are here, I don't want us to wait for the end of argument before judgment, because then the other side doesn't have the benefit of what you are saying under oath.
Yes, Justice Lukamani, might I just indicate that you recall that the applicants and ourselves are far apart, because we say the group is a confined group in terms of the criteria set out in the policy.
Yes.
They say the number is wider than that. So they're talking millions, we're talking 672. It's not material in that context, but we will obtain instructions why the information was not available, when did it become available, and so forth. But it should not detract from where we are. ETV's case is everyone. It's not per the policy. So it shouldn't really detain the court in a sense that there is some material consequence that will flow from this, because there's no acceptance that.
And I go back to what I told Advocate Marcus before, to say the progress with the smaller number helps us determine if we are to agree on the fact that everyone who is affected, then it gives us a reference point of how long does it take the minister to do certain things.
Thank you, Justice.
Mr. Sister.
Yes.
Mr. Mutau, from my side, in addition to understanding how many of the registered 672 have been installed, I would also want to know how many have been registered since 31 October, because there's this position on the papers that registration can continue. And we might also want to understand why it's 3 to 6 months to install after shut-off, given that on the numbers of 6,000 installers doing 4 to 6 boxes a day, it should be a matter of days, not a matter of months. But perhaps let's see where we get to. I agree with my sister that something sooner rather than later, so that the applicants and the interveners can address us on it, rather than we hear argument and then get some facts in. If we could accelerate getting it, and perhaps we need a lunchtime indication from all counsel if they have any objections to the court receiving that further affidavit today. But I think we've now interrupted Mr. Marcus on some housekeeping. But that, yeah, I think perhaps we should try to get that in. If everybody can indicate at lunchtime if they're happy with it, that might be a way to keep things on track here.
My brother, can we have a 15-minute comfort break?
Thanks, then we'll have a 15 minutes tea time. The court adjourns.
Thank you.
my learned friend's intervention about filing a further affidavit. Our position on that is the following. We cannot object to the filing of that affidavit, but we must, hopefully through the court's intervention, insist that at least they do so by not later than 4 o'clock this afternoon. Because depending upon what it contains, there may well be a necessity for us to file an answer to enable it to be dealt with tomorrow. So we would, if the court is disposed to permit this indulgence, then we would request that it be done by approximately 4 p.m. this afternoon to enable us to file a reply if necessary. Secondly, in relation to what that affidavit should contain, and in relation to the question posed by Her Ladyship Justice LaRue, may we point out that in our replying affidavit at paragraph 46 at 020-29, we said ETV invites the Minister to file a further affidavit detailing how many of the 670,000 set-top boxes have in fact been installed since 31 October 2021, and how many additional registrations have taken place since 31 October 2021. This would be of assistance to the court. So we would respectfully submit that whilst we cannot dictate to our learned friends what should be contained in the further affidavit, we point out that if they are deficient in any material respect, then they do so at their peril. And we, of course, make the obvious point that this any late further evidence will have implications for costs. Let me then deal with...
Mr. Marcus, just on the practicalities, obviously it would depend on what's in the affidavit. Obviously it would depend on how extensively you need to take instructions. But would you, if we were to give you an opportunity to respond, would you be able to do that before court starts tomorrow? You know, at least an hour before court starts tomorrow?
Yes, my lady. We'll give that undertaking that to the extent necessary, we will put up something by 9 o'clock tomorrow morning.
Okay, Mr. Mutau. Mr. Mutau?
Yes.
Did you hear that the requirement that you must file this affidavit by 1600 hours today? Is that what you'll be able to do?
Yes, Justice Nsimang, what we've done at the moment is we've indicated to the clients, and part of the client team are also online. So one of our team members is coordinating with the team from the department to ensure that that is being given effect to. And then we'll address other issues. But I should make it clear that ourselves and ETV are worlds apart. The issue relating to costs is completely relevant to their case, because their case is not 672.
That's fine. But let's talk. We're talking now about the affidavit. Will you be able to file? So you say yes. Thanks, Mr. Mutau.
Yes, this is the part I'm raising, Justice Nsimang. That issue is being attended to by part of our team. If there is any difficulty, I will come back and indicate to the court, but I don't envisage that there'll be any.
Okay, thank you, sir.
Thank you.
Mr. Marcus?
Thank you, my lord and my ladies. Well, that deals with the further affidavit. Let me make briefly some submissions on my learned friend's contentions before going on to my next topic. My learned friend has effectively made two concessions. He has conceded that the KZN principle applies to the 672,000. We, of course, submit, and I will deal with this in a moment, that it goes considerably beyond the 672,000, and in any event, it feeds in to our arguments in relation to the violation of freedom of expression and the duty to consult, which I'm coming to in a moment. So the first concession he's made is that the KZN principle applies, albeit that he seeks to limit it. The second implicit concession that he has made is in relation to reporting to the court, and that is part of the very relief we seek. Well, he is now at least undertaken to do that much in relation to the 672,000. The third point I would make in relation to my learned friend's concessions is that it feeds directly into our argument about lack of candor. And that lack of candor will continue, we assume, at least until 4 o'clock this afternoon. Let me briefly make some submissions on the ambit of the promise. I have taken the court through those promises going back to 2008, but the most important and the most recent promise is that contained in the Minister's media statement of the 5th of October, which I've read to the court. And that promise was in unequivocal terms. It said to give effect to a successful digital migration and analog switch-off process, we have to ensure that everyone who needs to migrate from analog to digital is ready to do so and are not negatively affected by the switch over from analog to digital. So the promise and the undertaking goes considerably wider than the 670,000. In relation to Justice Msimang's questions about the statistics, the obvious point with respect is that this is matter which is within the exclusive knowledge of the Minister. When the Minister made those promises from 2008 onwards, those promises must have taken into account the ambit of the promises that were being made, and to whom those promises were being addressed, and to the seriousness with which those promises were made so that they could be fulfilled. To put it differently, the onus is on the Minister in relation to those statistics, and she alone is in a position to provide them or not. And lastly on this point, as I foreshadowed, is that independently of any debate around whether the KZN principle extends beyond the 672,000, the numbers affected are squarely addressed also by our freedom of expression argument and our duty to consult. So the KZN argument is not a self-standing, and in KZN principle is not, from the purposes of our argument, entirely insulated from or independent of the other arguments. With that, could I then move to my third topic, which is the breach of the rights?
Mr. Matas, before you move on to your next item, just to clarify a little on the statistics that I was talking about.
Yes.
Is that it doesn't appear that there are statistics that have been compiled specifically to look into the matter of providing indigent people with set-top boxes. There's no report that specifically speaks to that. What's your take on that?
Thank you, my Lord. My Lord, my take on that is that what is clear is that the Minister herself chose to rely on those statistics, and therefore she must be taken to accept their accuracy. I take your Lordship and your Ladyships back to the media statement of the 5th of October to paragraph 2.1. And there it is spelled out. The government undertook to assist beneficiary households earning total salary of less than 3,500 Rand per month, with installation of set-top boxes to ensure universal migration. She then gives the statistics and she then references the Stats SA 2018 data. So, my Lord, quite independently of whether those statistics were specifically tailored for purposes of set-top box registration and installation is beside the point, because the minister accepted those statistics for purposes of complying with her constitutional duties and giving effect to her promises and undertakings.
But then, Mr. Marcus, if those figures are not reliable, on what basis will this court say that there are millions of people out there who deserve set-top boxes and who have not been provided with set-top boxes?
Well, my Lord, if this court were to find that those figures were not reliable, but were to acknowledge that the minister herself relied upon those very unreliable figures, then her decision can only be irrational, because rationality requires decisions which are based upon accurate findings of fact. And that has been laid down by our courts repeatedly. So I wouldn't want to stand in the way of the court finding that the minister's decision is irrational. I merely point out the consequences if this court were to hold that the very figures upon which the minister relied were not accurate. That in a sense would destroy the basis of the minister's decision making.
I say so, Mr. Marcus, I say so because your client is a Dominic Smith, is a litigant who is here before this court and also relies on those statistics and goes on further to disavow those statistics and say, in fact, these statistics are not correct, and comes with other statistics. So you see, that's my problem. And what statistics should the court rely on?
My Lord, we have taken the minister at her word. She has furnished the statistics which she sets out in paragraph 2.1 of her media release. If the minister's counsel or the minister herself wants to tell the court that she put out a misleading statement to the public, that the figures upon which she herself relied are inaccurate and the court shouldn't rely upon them, well, no doubt we will see all of that in the supplementary affidavit that the minister is going to file.
Mr. Marcus, just on this point as well, two questions. One, is the number of set-top boxes procured, is that a statistic that the court can somehow use? So that 1.45 million, which is roughly correlated to the number of people who registered so far, is that a statistic that either for the applicants or for the minister, is that a more reliable indication of need, if I can call it that? And a second question, just so you can get them both together, is you would of course accept that that it's reasonable for the minister to have set up a registration process, and that there is some obligation on households to put their hands up for a set-top box. And so the registration number is a useful indicator of need, at least to some extent, which is why I in particular am interested in the supplementary affidavit addressing how many people have registered since 31 October and as cut-offs are happening. So just, would you accept that the number of boxes procured or the number of registrations so far are some indication of need that we can try to rely on for either your case or the minister's case?
Yes, my lady, I do. I don't suggest that that is the totality of the relevant information, but I'm answering your narrow question. Are they statistics which are relevant in assessing both the extent of the need, the extent of the uptake, and the degree to which the state has complied with their obligations? Of course, I accept them as relevant. I do not accept them as complete.
Okay. And you accept that people can be expected to register?
Yes, I'm going to say something about that. Because the stance, I'm coming to it, but let me foreshadow it. The stance adopted by the minister and enthusiastically supported by Vodacom is that those who haven't registered, in other words, the poorest amongst us in South Africa, really have only themselves to blame. And I'm going to be suggesting to the court that that is an extraordinarily cynical argument to advance, but may I address that in due course when I come to it?
Of course, and let me then just note, because it's also something for Mr. Mutar to also address. I'm sure he's listening and will keep a note.
Certainly. All right. Thank you, my lord and my ladies. Can I then go to the third topic, which is the breach of the right to freedom of expression? And what we submit in this regard is relatively straightforward. We submit there cannot be any serious debate around the proposition that the guarantee of freedom of expression in section 16 of the Constitution includes the right to receive information and ideas. There might previously have been debate around that under the interim constitution, but the final constitution puts that beyond doubt, and we don't understand there to be any serious dispute about that. The second point we make, and we reference this in 3.2 of our references document, is that freedom of expression is a right which seldom exists in isolation. We say that because the Constitutional Court has made it clear that it is part of a web of mutually supporting rights. So, for example, in the Kwelani decision, which we reference in 3.2 of our notes, the court said that freedom of expression is constitutive of the dignity and autonomy of human beings, and it constitutes a web of mutually supporting rights in the Constitution. And I remind the court, and I give the references once again, to how that is consistent with the state's understanding of its obligations. I've referred to the extracts from the digital migration policy, in which they made it clear that they saw this as part of the poverty reduction goals of the state. I've given you I've read that passage to you before, and we've referenced it in 3.3 of our references document. So, on first principles, in circumstances where, and I'm going to use hopefully neutral terminology, in circumstances where large numbers of South Africans are at risk of having their right to access free-to-air television being cut off, there is an onus cast on the state to justify the limitation of that right. That is standard fundamental constitutional analysis. And the first requirement of limitation is that the limitation has to be in terms of law of general application. Now, we are told by our learned friends for the minister in their heads that the source of the power to determine the ASO is not the digital migration regulations. It is the digital migration policy. And policy is not a law of general application. So, on limitations analysis, if our learned friend's argument is accepted that the decision was not made in terms of the regulations, it was made in terms of the policy, they are simply unable to justify the limitation of constitutional rights. Again, that is standard constitutional analysis. In 3.4, we have given you two of the many cases, Hoffman versus South African Airways and August versus the Electoral Commission. In both of those cases, decisions limiting fundamental rights were taken in terms of policies and not laws, and in both cases, the limitations analysis was held, therefore, to have failed. And the same holds true here. I will later address the source of the minister's power to determine the ASO, in case this court were to find that the minister is wrong, and that the source of the power is indeed the digital migration regulations. But if we look then to what the minister's answer is to this leg of the argument, it's probably best captured in paragraph 203.3 of our learned friend's heads. We give you the reference at 3.6, but let me read it to the court. Our learned friends say this. They say the implementation of the ASO plan will not affect the section 16.1 rights enshrined in the Constitution. Everyone remains entitled to the freedom of speech and the rights set out in section 16.1 of the Constitution. The implementation of the ASO do not limit the section 16.1 rights of everyone. All this plan requires is that South Africans must either have an STB and or DTT enabled television sets. Those households that qualify for government assistance would have had to register for this. They have had a period of 6 years to do so. They were finally reminded by the minister in her final call, as reflected in the media statement of 5 October 2021. So that's their case on freedom of expression. We say that the argument is plainly unsustainable on the facts. We submit, and no doubt we will get further clarity on this later this afternoon, but that there are large numbers of South Africans, we suggest many millions of indigent South Africans who currently have access to free-to-air broadcasting via their analog televisions and who are reliant on government to provide them with STBs, and that these people are at risk of being cut off on the 31st of March. Now, I have mentioned the positive obligations of the state under 7.2, and the negative, I now go to the negative obligations, which also rest on the state, and you will recall that in the media statement, in the passage that I have twice now referred to, the minister undertakes to ensure that no one will be negatively affected by the cutoff. It is absolutely clear, and we have set this out, the authorities in paragraph 3.7, that the minister, in addition to her positive obligations, has a negative obligation not to interfere with the present enjoyment of the right to freedom of expression by analog viewers, and any such interference would only be constitutionally permissible if justified in terms of section 36. I've already made submissions on their inability to justify. I said, I think in answer to Justice LaRue's question, that I would deal with the question of registration. And what we see from our learned friend's argument is that the minister suggests that the registration window has been open for 6 years. And I characterize that as a cynical contrivance. And let me say why I do so. Again, I give you the references in 3.8 of my references document. It is not in dispute that the digital migration process stalled for a long period. So while notionally the registration window was opened, there was no indication that government in fact intended to proceed with digital migration anytime soon. The best indication of this is that despite the notional registration window being open since 2015, the government stopped installing STBs in January 2019, and only appears to have restarted in October 2021, thus leaving hundreds of thousands of registered indigent households without STBs for years, even though they had registered. Hopefully we will get the exact figures, but for present purposes, it is clear that between January 2019 and October 2021, registration was evidently pointless. And here's the important point. At no point prior to the sudden announcement of a registration cut-off date, with at most 3 weeks' notice, but in practice probably none, that government ever suggested a cut-off date would be imposed, or that it would again proceed with installing STBs, which had stalled in January 2019. So in summary, by January 2019, far from sensing or knowing or being told that there was a continuing need to ongoingly register or visit post offices to obtain registration, or else that their televisions would be rendered redundant. Instead, the digital migration process effectively had ground to a halt. The public generally, and the indigent in particular, far from being on alert as to the need to obtain a set-top box or arrange their affairs urgently to do so, had at least been lulled into thinking that the process was in neutral, if it was alive at all. But all of that suddenly changed, without warning and without consultation. And then the minister makes the astounding suggestion that it is reasonable to expect these eligible and poor households, who hitherto had not been alerted to the need urgently to obtain set-top boxes, to radically arrange their affairs to register on 3 or less weeks' notice. And that is what we say is a cynical suggestion. It is cynical to suggest that vulnerable individuals were holding government back and needed to be chivied along to meet the deadline, when in fact all the delays, false starts and restarts to date were the government's fault. We suggest that unreasonableness is palpable. So one of the exercises that this court will have to undertake if the justification analysis is reached, in other words, if our learned friends can either overcome the fact that the decision was taken in terms of policy and not law, or if the court accepts that in fact the decision was taken in terms of the digital migration regulations. A critical question in the limitations analysis is whether there is a proportionality regarding the extent and nature of the limitation of the rights in question. What we would respectfully submit, that given the precipitous process, given the history in terms of which the process had stalled, given the absence of timeless notice, we would submit that the outcome, the effect, is utterly disproportionate. We had indicated, and this has been the subject of some discussion already, that we invited the minister to provide the requisite information. We give you the references in that regard in paragraph 3.9 of our note, and we submit that it was incumbent upon the minister to provide that information consistent with her constitutional duties, and particularly the duty of candor in litigation. We have referred in that regard to a number of authorities which reflect the principle that, notwithstanding the fact that something is said in reply, there is no bar, indeed there is sometimes an obligation for that matter to be dealt with in a further affidavit. We've given you 3 authorities in paragraph 3.10 of our notes. Perhaps the clearest example is the case of Milan versus City of Cape Town, which we have referenced in that note. Those principles are not controversial, and we submit it is not necessary to repeat them here. But if one goes to proportionality, then we submit the impact of cutting off people in large numbers is utterly disproportionate to whatever legitimate aim the state seeks to achieve. We refer in that regard, and you'll find it in 3.14 of our note, to the SCA decision in MediRight, in which the court emphasized, and I quote, "It has been stated that proportionality is a constitutional watchword, and as was observed by Plaskett J. in Ehrlich, quoting with approval the views of Professor Joel, unreasonable administrative action includes those that are oppressive in the sense that they have an unnecessarily onerous impact on affected persons, or where the means employed, albeit for lawful ends, are excessive or disproportionate in their result." So we can accept, for purposes of this debate, that there is an entirely legitimate concern by the state to migrate from analog to digital. We don't dispute that, and we've made that clear in our affidavit. The real question is, are the means adopted by the state to achieve that legitimate end proportional to the impact on the limitation of the rights of those who are directly affected? And part of that proportionality inquiry, as we well know in constitutional law, entails posing the question, are there less restrictive means to achieve the desired result? And they plainly are. This is a process which has taken many years, a delay of a few months to enable the limitation of many numbers of South Africans' rights to receive broadcasts would be entirely appropriate. There is a necessity to ensure a proper and efficient registration process. That kind of information has simply not been provided. So we would submit...
Mr. Marcus, arising from what you're saying on the proportionality of this, will that also include, because I see most of the arguments is on the basis of the people who will be denied access. But does it also include, should we also look at the benefits of delay of the switch off? Because we should also look at that, because even the very people who we can say will be prejudiced are likely to benefit from the benefits that flow with that. Shouldn't we look at that as well?
My Lord, I don't suggest that the court should close its mind to any relevant consideration. And to the extent that your Lordship suggests that juxtaposed with the prejudice to potentially millions of South Africans, one needs to put in the scale benefits, I would not cavil against that suggestion. I would accept it. I am unsure as to what those benefits might be, and I'm equally unsure as to whether those affected who might be cut off for up to 6 months or more would see that as a benefit. But at the level
I could sense that you are begrudgingly accepting that.
I'm not, it's not a begrudging acceptance, my lady. Let me be clear. I accept that this court, in the proportionality analysis, must take into account all relevant considerations. And to the extent that the court is of the view that there are benefits that will accrue to the affected people, I would not be heard to say the court should not take that into account. I'm simply that I struggle to see what those benefits are.
Mr. Marcus, and you also said for a few more months, they can wait for a few more months. What if we are being practical about this matter? What if you say a few more months? What do you have in mind?
Well, my Lord, I'm indebted to your Lordship for raising the issue of practicality, and it is precisely for that reason that we considered it appropriate to include reporting relief, to put the court in a position to make precisely that kind of informed decision. Once again, we are held hostage to the minister, because it is the minister who has all the critical information, and it is the minister who has thus far chosen not to provide the relevant information to the court. So your Lordship asks, well, how long? I'm not in a position to answer that question because we don't have all the information. But the information which is hopefully furnished by 4 o'clock this afternoon, and the information which would be furnished by way of a reporting obligation to this court, ought to be sufficient to fill the gap.
Mr. Marcus, just on that, and I don't want to anticipate your final topic, the remedy, but reporting relief. Sorry, I don't know if you can hear me.
Would you mind just repeating that, please?
I don't want to anticipate your remedy argument on your final topic, but paragraph 5 of your notice of motion, and I must just ask you if there was in fact another notice of motion filed, because your replying affidavit, para 142, said that there was another notice of motion filed with that affidavit, but I don't have it on case lines. So I only have one notice of motion, the October notice of motion. So para 5 of the October notice of motion says on the reporting relief, if you could address us when you get to remedy on whether that reporting relief in the end makes the court determine when ASO happens and the appropriateness of that. And then while I've got the floor, if I could raise another question with you on my list with respect to the limitation of rights, just to get your client's submission in response to the argument that says you can't say that free-to-air television is coextensive with the right to obtain information, because the same people who will have free-to-air television turned off may access information from several other sources, and that on the papers we simply don't know how many are exclusively or predominantly reliant on free-to-air. Thank you.
Respectfully, my lady, on the latter question, it simply ignores the negative obligation on the state. If as a fact, and we know this is a fact, there are many millions of South Africans who are dependent on free-to-air television, and come the switch-off date, that will be taken from them, then they are deprived.
But how do I know they are dependent? How do I know they aren't in this world that the respondents tell the court exists, where people have multiple sources of information?
Well, again, do we take the minister at her word or not?
The facts before the how many people are dependent in the papers and don't have other sources of information?
I can't give you exact numbers, but if we take the ministers at her word, as we are entitled to, we know that it runs into vast numbers. We know, because the minister says as much in as many words, that comes the switch-off date, they will be denied that access. We're also dealing with people who earn less than 3,500 Rand per month. Milady, it's difficult not to get irritated, if I may, with the arguments of our learned friends in that regard, because it seems to be based upon really a cynical disregard for the material conditions under which many people live. Now, I can't tell the court that there are none amongst those people earning 3,500 Rand or less who won't have access via smartphones and the like. And that's no part of my argument. But we live in the real world, and the court is entitled to accept that whatever the exact number may be, there are going to be vast numbers who are cut off. And the minister knows that, and she has said as much repeatedly, and she has promised to ensure that that will not occur. Can I then turn to my fourth topic? And I will try, in some respects it has been addressed, but there are aspects of it which I do want to emphasize. It's the duty to consult, and it's addressed in paragraph 4 of our reference documents. And I start with precedent. And I suggest that there ought to be, I underline the word ought because I'm wrong in this, but there ought to be no real dispute that the minister was duty bound to consult with interested and affected parties about the ASO, because that obligation had twice been affirmed by this court. It was first affirmed by Justice Sutherland, and it was subsequently again affirmed by Justice Bakwa, and I give you the references in 4.1 of my note. And on this score, and this is important, nothing turns on whether the decision on the ASO is administrative or executive in nature, because the right to be heard arises in relation to either situation. Now, I'll expand on that. I just want to say something, and very briefly, about what the nature of the obligation to hear the other side entails. It is, first of all, a very old principle of the common law, which arises whenever any decision is taken which affects the rights or property of anyone. And I give the common law authority of Administrator Transvaal versus Troe. But I do point out that it has been recognized by our courts that the decision is hundreds of years old. It was articulated in a case to which I refer in my note in 4.2, R versus Chancellor, Masters and Scholars of the University of Cambridge. In that case, the court traced the right to be heard back to the Garden of Eden by pointing out that God, who is omniscient, gave Adam a hearing before expelling him from the Garden of Eden. And that principle was acknowledged by our courts on many occasions, and I've given you merely one of the many examples in Panda Foodliner in my reference. But to now take that to where we are under a constitutional dispensation, the Constitutional Court has described the right to be heard as the procedural component of the rule of law. It did so in Walele's case. I've given you the reference in 4.3. So we're dealing with a principle which is absolutely fundamental to every legal system which prides itself on the protection of constitutional rights. And it is a matter of astonishment that the minister in her heads of argument denies that there is any duty to consult. I say a matter of astonishment both at the level of principle but also at the level of fact. And I say so because it is extraordinary that the minister should deny any such duty in circumstances where the right to be heard is not simply about respecting the dignity of those in respect of whom an adverse decision is about to be taken, but it is as much in the interest of the decision maker to ensure that the decision is accurate and rational. And that is why we refer in our heads and in our note to Joseph versus the city of Johannesburg. I give you the reference in 4.5, where the court made this point as explicit as it could be made. The court said procedural fairness. I beg your pardon? Justice, I'm sorry, Justice Simang.
No, it's not me.
I'm sorry.
It's interference, it's interference. When analog and digital meet, there's always interference.
I understand. I merely quote what Joseph said because it makes the point as well as I could. It said, procedural fairness is concerned with giving people an opportunity to participate in the decisions that will affect them, and critically a chance of influencing the outcome of those decisions. Such participation is a safeguard that not only signals respect for the dignity and worth of the participants, but it is also likely to improve the quality and rationality of administrative decision-making and to enhance its legitimacy. And that's precisely the concern with which the court is faced here. You are confronted with a minister who has made continual promises, who has broken those promises, and who now disputes that she was under any duty to consult at all. And she does so in circumstances in which the path that she was about to follow would have a very serious impact on not one, but 3 democratic principles at the heart of our society. Namely, that the government must take all reasonable and effective measures to protect the poor from retrogressive steps, that the right to receive broadcasting is a fundamental right to receive information, and that the receipt of that information is critical to political expression and democratic debate. We say that in paragraph 102 of our heads, and we reference it in paragraph 4.4 of our note.
Mr. Marcus, on the right to be heard,
Yes.
Firstly, the digital migration and the award of the spectrum IMT 778, that is something that was agreed at the ITU convention. So the migration issue is something that has to happen in Region 1. We are agreed. There's no consultation with anybody there because we have to migrate. So the next thing is when we suppose now to implement the migration, because switch off is the last day at the end, switch off, and then the minister can say that I can, the policy says I can switch off or switch off, but the migration into the new system, who are the people that are supposed to be consulted? I tell you that according to these papers, the other players in the broadcast would have been Telkom, would have been Eskom, rather. Hey, what's happening? The other players would be SABC and MNET. And of course, ETV. So when we talk consultation, is that the other players, SABC and MNET, have switched off their transmitters. And surely they must have been consulted for them to get to that stage. And ETV, memory tells, if I were to recall well, is that we've got 91 transmitters and they've only switched off how many? 4? So I'm saying they have not been consulted.
My lord, let me attempt to answer your question. And let me make it clear that I am here to speak for ETV and not for the other players in the market. I'm about to come to the aspects of proper consultation, underline the word proper consultation with ETV. I'm going to address that in a moment. And I also, of course, make the point that consultation extends beyond the commercial players in the field. Consultation extends to those who are directly or who will be directly affected by the ASO. So the consultation is not, and I do need to emphasize this, my lord, it is not confined merely to the commercial player. So I'm going to make 2 submissions in a moment. I'm going to, first of all, postulate a hypothetical scenario, not hypothetical, an abstract scenario, as to what proper consultation would require, and then invite the court to compare that with what actually happened. And when I do so, I'm doing so in 2 respects. I'm doing so in relation not simply to ETV, but also in relation to those who would be affected by the switch off. So if one looks at it in that way, and as I say, if we do a before and after comparison, I would respectfully submit that the answer to your lordship's question will be absolutely clear. So if we were to postulate this scenario, there would be at least the following elements to a proper consultation process. First of all, it would be a recognition that it is a process, and that process would entail ultimately, as your lordship has rightly pointed out, the determination of a date for the switch off. Secondly, when the ASO occurs, we know that those without set-top boxes will not be able to receive television broadcast. And we know also that in the present case, that entails a large number of people who are at risk of being left behind. Thirdly, we know that the minister has made repeated public promises and assurances that no one would be left behind, so that the process of consultation would need to include how registration would take place and ultimately installation, and it would have to have regard to the gap between registration and installation. Fourthly, and related to the previous point, a proper process would have to ensure that provision is made for those who failed to register.
Someone seems to be typing over the audio on my side. I don't know, so I'm catching every second word. I don't know if anyone is having a similar problem.
Yeah, I do have this interference. Can we ask everybody, please, let's switch off our gadgets, let's not do other things, even the cell phones, and because there's clearly interference, and you're interfering with Mr. Marcus. We want to hear every word he said. Mr. Marcus, there was some interference there. That is why my sister came in. You may proceed.
I'm indebted to your lordship. So if I pose that abstract scenario as I have, reduced to its basics, the minister would have to consult about the registration for STBs, the date by which this should occur, and of course the minister would have to consult about the switch off date. And of course, when I talk of a proper registration process, that postulates that the minister would have to do so with an open mind, with a mind open to persuasion. And equally importantly, in order for that consultation process to be proper, she would have to furnish interested and affected parties with some basic information. And that brings me to what I foreshadowed to your lordship, was how did that play out in fact in relation to ETV? And that is reflected in what I have termed the saga of the 6 letters. And I deal with those 6 letters in paragraph 5 of my note, and of course it is dealt with in considerable detail in the founding affidavit, which set out in some detail ETV's attempts to get clarity from the minister regarding STB registration and regarding the switch-off date. And
Mr. Marcus, there, can I come in? I'm sorry. Before, on the 6 letters, because those 6 letters show, a hyperactivity from the 2nd of September and up until October, but 6 letters written in the space of 6 weeks. Then I looked at the telecom application, which wanted to anticipate the switch-off date to June 2021. That matter was settled in September, around September, and that's when ETV, which initially was saying wanted to anticipate the switch-off date, apparently they filed a notice of amendment to say, no, we don't want that. So that was in September, and the stance that you want to anticipate the switch-off date in maybe the end of August or beginning of September, you decide, no, I don't want the switch-off date anymore. Then there's a hype of these letters. What should I make out of them before you even discuss these letters?
My lord, I wonder whether I understand your lordship's point very well, and it in fact is part of my setting out of the saga of the 6 letters, and it arises at the time, I think, of the 5th letter. And I wonder if I could just take you briefly through that, but I will address your lordship's point. Bear in mind, my lord, that the point that I'm raising here, and that I'm seeking to persuade the court of, is that in relation to ETV, there wasn't proper consultation at all. That's the point that's the end point. But let me demonstrate why, and I will deal with your lordship's question, I believe, when it comes to the 5th letter. The 1st letter was on the 2nd of September. It's Annexure PR6. It's referenced in 5.2 of my references document. It's a long letter, but in summary, it sets out the impact of the ASO in the light of the minister's then intention to fast-track the digital migration policy. It draws attention to the rights which are implicated, particularly Section 16. It draws attention for the need for arrangements to be put in place for accessing free-to-air television broadcasts when the switch-off occurs, and the numbers who are potentially affected. It refers to the state's continual promises that no one will be left behind and why the state is bound by those promises. And it sets out ETV's contentions on what the preconditions are for a lawful digital migration process. It draws attention to the obligation to consult as reflected in the judgments of His Lordship Justices Sutherland and Bakwa, and it makes a request for undertakings regarding a process of engagement and the meeting of preconditions for a lawful migration process. So the building blocks, for want of a better description, of this entire case are in fact set out in that first letter. There was no response to it. The second letter was on the 13th of September. It's Annexure PR8. It's referenced in 5.3. It again sought the same undertakings regarding a lawful migration process and specifically asked the Minister to confirm whether she accepted the requirements for a lawful digital migration process. No response was received to this letter. The third letter was on the 19th of September. It's Annexure PR9. It's referenced in 5.4 of my notes. It recorded the failure to respond to the previous letters. In anticipation of a meeting with the Minister, ETV sought responses to the outstanding letters and additionally requested information about the proposed plan for implementing the digital migration process. No response was received to the letter. The fourth letter was on the 23rd of September. It's Annexure PR11. It's referenced in 5.5 of my notes. Once again, ETV requested an answer to the questions posed in the previous letters of 2, 11 and 19 of September. No substantive response. Then the fifth letter was on the 1st of October. It's Annexure PR13, referenced in 5.6. It opened with a reference to the previous unanswered letters, and those letters are in fact referenced throughout this particular letter. It expresses the concern that the Minister's plan was already a done deal and that this had all occurred without a public consultation process. It suggested that the Minister's plan was unachievable. Shortly before this letter went out, and this is important, this letter was on the 1st of October, but shortly before this, on the 29th of September, the Presidency issued a statement on a cabinet meeting. It's Annexure PR14, it's referenced in 5.6 of my notes. And that statement said that Cabinet approved the revised integrated analog switch-off implementation plan, which is a schedule to complete the remaining areas by March 2022, and that is what the Cabinet statement said. And so the fifth letter justifiably recorded in paragraph 11 that the fact that the digital migration plan was approved at the Cabinet meeting before the meeting at which ETV was to present its alternative plan simply underscores the fact that the invitation to ETV to make a presentation of an alternative plan is an exercise in futility. And that the letter goes on to say that in addition, for the reasons which are previously conveyed by ETV, there has been no meaningful engagement with ETV or with the variety of concerns which ETV has raised in relation to the fast-tracked digital migration process. And the letter goes on to say in paragraph 14, in the circumstances, we require your urgent confirmation as to, one, whether the Minister informed the Cabinet of the serious concerns which had been raised by ETV regarding the digital migration plan, which has now been adopted, 2, which plan was approved by Cabinet, and 3, confirmation of the process of engagement that led to the adoption of that plan, including with the public and affected stakeholders. That fifth letter attracted a token response, this time from the State Attorney. You'll see it referenced in 5.6. The State Attorney writes a letter dated the 5th October, and he says the issues raised in your letter were overtaken by events in light of the withdrawal of the application filed on 8 September, which will be replaced by a fresh notice of motion and competent finding affidavit under a new case number on 12 October as agreed. Now that's where your Lordship's question comes in. Now that answer from the State Attorney is simply not a correct reflection of the facts. The correct facts are set out in the founding affidavit, and I give you the reference at 5.6, in paragraph 125 of the founding affidavit, it records the receipt of the letter from the Office of the State Attorney, and then it goes on to say in paragraph 126, this letter further confirmed the Minister's complete failure to acknowledge and engage with ETV's concerns, and her indifference as to the detrimental consequences that would issue to free-to-air broadcasters and the general public alike as a result of the Minister's decision to fast-track digital migration. And here, critically, is the answer to your Lordship's question. Most obviously, ETV's application of 8 September for amended relief had not been withdrawn. It had instead, under direction of Fourie J, been consolidated into one new affidavit and notice of motion to streamline the process towards an expedited hearing. The State Attorney's letter, through its formalistic approach to what happened on 5 October at case management, was thus aligned with the Minister's continued refusal to provide any information or engage with the substance of ETV's concerns. Then came the 6th letter on the 6th of October, it's Annexure PR 16. We reference it in 5.7. The Minister was yet again asked to respond to previous correspondence and to provide critical information. It referenced the 5 previous letters. Answers were once again requested. On 10 October, there was a response to this letter from the State Attorney. It's Annexure PR 18, and it was a refusal to respond. That letter is referenced in 5.7 of our notes. What the State Attorney says is that we do not intend to litigate the matter by correspondence. In light of the pending litigation, our client will not respond to your request for undertakings through correspondence. As is appropriate in the circumstances, they will be addressed in our client's answering affidavit, which will be delivered in terms of the timetable agreed to at the case management meeting. So, all attempts to obtain the most basic information, which is necessary for proper consultation, having failed, ETV in its founding affidavit called upon the Minister to answer the questions regarding the undertaking and the minimum requirements for a lawful migration process. You will find that, and I'm afraid this is one of the few references not in my notes, but you will find that in the founding affidavit at paragraphs 148 to 150 at 001-60 to 61. The Minister, in the result we submit, failed to provide ETV with a clear answer as to what process was being followed, what effect that process would have on ETV's ability to transmit analog signals, and how those without the means to access digital transmission were to be catered for. The Minister was expressly called upon in the founding affidavit to answer the questions regarding the undertaking and the minimum requirements in her answering affidavit, and to explain the basis for her refusal to provide those answers in response to the 6 letters. That, as your Lordship and Ladyships know, is not, has not occurred. So instead, on the 6th of October, which is the date of the 6th letter itself, the Minister chose to issue her media statement. That is the media statement to which I've referred a number of times. It's Annexure PR 17. I once again give you the reference in 5.9 of my notes, in which the Minister confirmed that she had committed herself to the 31st of March as the cut-off date. She once again undertook to assist those who earned less than 3,500 Rand to get set-top boxes, and she promised that no one would be left behind. So if I could simply ask the court to go back to that exercise that I proposed by postulating what a proper consultation process would require and compare it with what actually happened. And the answer respectfully is clear. There was simply no proper consultation process at all. Now, our learned friends realize that this creates a potentially insurmountable problem for them. Faced with the facts relating to the minister's failure to consult properly or at all, which would otherwise be fatal to the process, the minister has come up with a new and we submit startling argument. We are now told by our learned friends that the minister was under no duty to consult at all. And in this way, the minister seeks to render any failure to consult properly to be irrelevant. How does the minister, or how do our learned friends get to this? They do so in seemingly two interrelated ways. They first contend that the decision on the ASO is an executive decision, and so does not attract the requirement of procedural fairness. And secondly, as I have foreshadowed, they contend that the source of the minister's power to determine the ASO is the policy on digital migration and not the digital migration regulations. Let me start with the first of these devices, and that is whether or not this is an executive decision. And I ask the court to assume, for purposes of my argument, that it is an executive decision. I, of course, do not accept that that is so, and I will address it in a moment. But I take on my learned friend's argument, as it were, in his own backyard, and I ask you to assume that it was an executive decision. The fact that it might have been an executive decision does not insulate it from the requirements of procedural fairness, where a rational decision-making process calls for interested parties to be heard. We cite several authorities in this regard. We give them to you both in our heads and in our notes, 5.10 of our notes. The most convenient one is Minister of Home Affairs versus Scalabrini, because that brings together the other cases, constitutional court cases in Albert and in Democratic Alliance, and in Scalabrini in paragraph 68. The court makes the point absolutely clearly. It said, there are indeed circumstances in which rational decision-making calls for interested persons to be heard. That was recognized in Albert, which concerned the exercise by the President of the power to pardon offenders whose offences were committed with a political motive. One of the questions for decision in that case was whether the President was required, before exercising that power, to afford a hearing to victims of the offences. It was held that the decision to undertake the special dispensation process under which pardons were granted without affording the victims an opportunity to be heard must be rationally related to the achievement of the objectives of the process. They then quote from that decision. Now that is precisely the same situation here. In the Scalabrini case, which concerned the closure of a refugee reception centre, the court said this at paragraph 70. In this case, the Director General was pertinently aware that there were a number of organisations, including the Scalabrini Centre, with long experience and expertise in dealing with asylum seekers in Cape Town. His representative, Mr. Yusuf, who had specially undertaken to consult with those organisations, on any process to close the Cape Town office. In the absence of any explanation for not having done so, I am left to infer that the Director General's failure to hear what they might have to say when deciding whether that office was necessary for fulfilling the purposes of the Act was not founded on reason and was arbitrary, even more so to stage what was in truth a charade that could only have misled interested parties as to the intentions of the authorities, which was inconsistent with the responsiveness, participation and transparency that must govern public administration. Well, we submit, my Lord, respectfully, that this is an R40 case. My Lord, I see that it's 1:01. I'm entirely in your hands. I know we had something of a late start, but and I'm happy to continue, but I will be guided by your Lordship and your Ladyships.
Are you comfortable with stopping at this stage?
I'm comfortable to stop or to carry on. I'm in your hands, my Lord.
My sisters, I think maybe we should take lunch so that we should be able to refresh and come back. But when we come back, Mr. Marcus, the question that I posed to you, I would like you to look at your papers again and come back to me on that thing, because it seems to me that ETV all along in the interaction with the minister, because these people have been litigating against each other in many cases, you know. In its interaction with the minister, in one case, it was to anticipate the switch off. And I would imagine the parties were engaging each other on that. And then you get, in the next month of September, the complete opposite of that. Now the ETV wants to say, I want to bring my own plan and write 7-10 letters in 1 month. So I just want, how do I reconcile those two? Because have those letters been written specifically to make out the case of barraging a minister with letters, when actually in the other case you were asking for the opposite? So I just want you to tell me let's reflect on that, because it tells me that how serious is this? Are these 6 letters if 2 weeks back this person was standing on the other side of the field? So we can do that. We can come back to me at 2.
I've got your Lordship's question. My Lord, till what time do you wish to adjourn?
Adjourn until, my sisters, what time do you, is it an hour? 45 minutes?
I'm happy to come back at 10 to 2.
10 to 2. 10 to 2 it will be. The court will adjourn.
Thank you, my Lord.
Or the clerk, I don't see my clerk on the screen there. But is all cancelled here, Mr. Marcus?
There she is.
Yes, my lord.
Oh, okay. I see. Oh, we are all here. Mr. Marcus, the floor is yours.
I'm indebted to your lordship, and I'm also indebted to your lordship for the opportunity to address the concerns that your lordship raised with me just before the lunch adjournment. I think before rounding off the points that I was dealing with, perhaps I should deal immediately with your lordship's question and then go back. Your lordship had suggested to me by way of a question that ETV is being inconsistent if one compares its stance in the previous litigation with the present. Respectfully, my lord, that is not correct. In fact, it is explained in ETV's replying affidavit obviously this is not in my notes, but it is explained in the replying affidavit at paragraphs 136 to 139, which you will find at 020-65. Perhaps I could just take you through those paragraphs because it says it all. It says in paragraph 136, Vodacom alleges a volte-face on the part of ETV between the first ITA spectrum application, because Vodacom alleges ETV supported Telkom's relief, including an accelerated timetable for digital migration. This submission is not correct. ETV supported Telkom's principal relief only in relation to the interdict and review of the ITA. ETV participated in that litigation as an intervening party. At paragraph 5.2 of the founding affidavit in the intervention application, it is stated that ETV supports, quote, the principal relief sought by Telkom in respect of Part B of the application which Telkom has brought, and that ETV, quote, makes common cause with Telkom and the principal relief it seeks in its application. Furthermore, in the supplementary founding affidavit, paragraph 222, ETV recorded that it supports the relief sought by Telkom in Part C. It explains, however, that, and here's the critical part, ETV has repeatedly made it clear to representatives of the Department of Communications that digital migration can only take place if there are a sufficient number of reception devices available at the right place and time, b, adequately resourced call centers to process viewer queries sufficiently and effectively, c, an effective viewer information campaign, d, sufficient Centec resources to action the switch off of transmitters, amongst other considerations. And those extracts are attached. It goes on to say ETV's submissions in the first Telkom application are entirely consistent with ETV's submissions before this court pertaining to the prerequisites of a lawful digital migration process. My lord, moreover, in the minister's answering affidavit at paragraph 637, which you will find at 009-155, the minister said, I have already said that the points raised by ETV in its various letters are points that it has been raising since at least February 2021. The minister has taken on board and has considered the points made and will in due course announce when the ASO will happen. In other words, my lord, the point I'm making here is that the point I'm making here, my lord, is that contrary to any suggestion of inconsistency, the minister seems to accept that ETV had not changed its position. My Lord, that is further reinforced by a letter written by ETV to the Director General on the 22nd of February 2021. Your Lordship will find that as Annexure AA8 to the Minister's answering affidavit, and that is to be found at 010-758. You will see that that is a letter dated 22 February 2021, i.e. more than a year ago, and it's paragraph 9 of that letter, at which you will find at 010-761. The numbering goes awry, but it starts with paragraph 9, which says, "We draw to your attention the following issues which were raised during the meeting by ETV in relation to the proposed draft plan." The next subparagraph is wrongly numbered 8.1 because it follows 9, but it says, firstly, transmitters cannot be switched off without sufficient market intervention in the coverage area of the identified transmitters. This is so because there are insufficient DTT decoders available for purchase, and they are also not affordable for indigent viewers. This is confirmed by the fact that approximately 63% of television viewers in South Africa still receive their signal through analogue terrestrial. It goes on to say, secondly, it does not appear that any careful planning or thought has been given about how specific geographical areas and affected households will receive television signal after the proposed analogue switch-off. Thirdly, it is practically impossible to achieve nationwide or even provincial-wide transmitter switch-off within the proposed timeframes, and it goes on to elaborate on that. It says, fourthly, there is currently a worldwide shortage of chipsets to manufacture decoders. So, my Lord, it demonstrates, we respectfully submit, that there is no inconsistency in the position adopted by ETV, and the writing of those 6 letters and the information sought in them was consistent with ETV's stance from the outset. But your Lordship posited to me the question whether those letters were seriously intended. As already indicated, I understood that question to be premised on the proposition that ETV was adopting an inconsistent stance. As I've attempted to demonstrate to your Lordship, that respectfully is not correct. Perhaps more importantly, though, my Lord, is that those letters had to be written if there was to be a proper consultation process, because the information which was sought was not publicly available. It was therefore necessary that that information be provided for purposes of proper consultation. And moreover, it was, of course, well known to the minister that ETV was a vitally interested party, hence the dictum in Scalabrini, to which I have already referred, bears emphasis. My Lord, without wishing to labour the point, I do want to stress that for consultation to be meaningful, it is absolutely vital that the affected parties be provided with critical information so that they know what to consult about. And that is not a new principle, my Lord. That is an old principle. It goes back virtually 100 years in our jurisprudence. One of the leading cases, as your Lordship may well know, involved the famous trade unionist Clements Kadali in a case called Kadali versus Hemsworth, 1928 TPD 495. 1928 TPD 495 at paragraph 506, where obviously in a different context, but the court said this: a man cannot meet charges of which he has no knowledge. A man who has to give evidence that he is of a respectable and deserving character is merely beating the air if the tribunal before which he goes declines to give him any indication of the points against him and which have to be met. And my lord, equally so, again, in many years ago, in a case called Sullivan versus Wheat Industry Control Board, 1946 TPD 194, after referring to Kadali's case, the court observed at 206, of recent years, the tendency on the part of our courts to require that any quasi-judicial or administrative body or officials exercising a discretion for or against a member of the public should not, so to speak, keep anything up his sleeve, but should, on the contrary, put fairly to the persons concerned any points against them, and this has been widened and strengthened of recent years. So my lord, respectfully, there is nothing sinister or untoward in the writing of the letters. The stance adopted by ETV, as is demonstrated, has been consistent throughout. So respectfully, my lord, I hope that addresses such concerns as your lordship has. If I could go back to where I was addressing the minister's attempts to evade the duty to consult. I had dealt with the first such attempt, and that is to characterize the decision as being executive in nature, and therefore to ostensibly escape the duty to consult. I demonstrated that even on that supposition that it was executive in character does not escape the obligation to consult. I've referred you to the authorities. Let me then go to the second attempt by our learned friends to escape any duty to consult, and that concerns the source of the power. Our learned friends suggest that the source of the power to declare the ASO is the digital migration policy. First of all, let me point this out, and you'll find this in 5.11 of my references, that the stance now adopted in heads is inconsistent with the minister's affidavit. The minister said in her answering affidavit, and I quote, "The regulations empower the minister to determine the ASO date." You have the reference in 5.11 of my references document. Now there is a change of stance in our learned friends' heads. They say, no, the source of that power is the BDM policy, and that error, and it is indeed an error of law, and it is material, is in fact perpetuated by the minister's determination in the Gazette. And you will find the Gazette, it's been placed as part of the papers. It's the Gazette of 28 February, and it's at 023-1. And you will see, I've referenced this in 5.12 of my notes. The opening paragraph indicates that the decision has been taken under paragraph 3.3.1 of the Broadcasting Digital Migration Policy. And if one has regard to the letter from the State Attorney dated the 28th of February 2022, which is also part of the papers at 023-2, you will see that the State Attorney, on behalf of the Minister, perpetuates that error. The State Attorney says, "This letter serves as notification that the Minister of Communications and Digital Technologies in accordance with paragraph 3.3.1 of the Broadcasting Digital Migration Policy has determined the date. While we are on that letter, because this is important, the State Attorney says at the foot of the page, the Minister is mindful of the litigation relating to the matter and that it has been set down to be argued on 14 and 15 March. The Minister is also mindful of the time and delay considerations, in particular the negative consequences that these have had on the entire country, and therefore needs to strike a balance between these two important issues. And then going on the third last paragraph, the Minister has been informed that the litigation is proceeding under supervision through a process of case management, and that the court has been specifically requested to give its judgment prior to 31 March. In this regard, and this is important, it is important to indicate that if the matter is determined in favour of ETV, the Minister will respect the judgment and act in accordance thereof. Should the court determine the matter in favour of the Minister, having published the date of final switch-off of analogue signal before 31 March, will enable the Minister to meet the 31 March 22 deadline. It is in this context that the Minister's actions should be understood. So, the stance adopted is that the source of the power is policy. The Gazette suggests that the Minister believed she was acting in terms of the policy. The State Attorney's letter repeats what we submit as that error and says that it is in terms of the policy. I have previously indicated that if that is indeed the case, it is fatal to any attempt to justify the limitation of rights, because that requires a law of general application. But I wouldn't wish to be the one to induce this court to adopt a wrong position, even if it is good for us on the basis of our learned friend's argument. What we submit is that the correct position is that a policy determination is not an empowering provision, and therefore the Minister committed a material error of law in her belief that the policy empowered her so to act. The position is accurately stated by the Supreme Court of Appeal in the Akani case, the reference to which we give in paragraph 5.13 of our notes. There, the SCA observed that laws, regulations and rules are legislative instruments, whereas policy determinations are not. As a matter of sound government, in order to bind the public, policies should normally be reflected in such instruments. Policy determinations cannot override, amend, or be in conflict with laws, including subordinate legislation. Otherwise, the separation between the legislature and the executive will disappear. And that the digital migration policy is policy and not law is confirmed by the Constitutional Court in the electronic media network case. Again, we've given the reference in 5.13, where the Constitutional Court referred to the digital migration policy and found that it was not binding and, quote, but a set of guiding principles. So let me pause here. Assume our learned friend's argument about the source of the power to declare the ASO is correct, and that the source is the digital migration policy. That does not in and of itself preclude the necessity for proper consultation. We submit, however, that the correct legal position is that it is the digital migration regulations which confer that power, as is made explicit in Regulation 3.1 and as was previously accepted to be the case by the Minister in her answering affidavit. So, if we are correct and the Minister is mistaken, then the source of the power is the digital migration regulations, not policy, and the question then becomes whether the Minister's decision is of an executive or an administrative nature. I've already indicated that that classification doesn't help the Minister, but if this court is to get it right, then we would submit that the source of the power being the regulations, it follows as a certainty we submit that the power in question is administrative. We refer in our notes to the famous case of Gray's Marine. We reference that in 5.14, where the court said of administrative action that it is conduct of the bureaucracy in carrying out the daily functions of the state, which necessarily involves the application of policy, usually after its translation into law with direct and immediate consequences. Our learned friends, however, fixate upon the notion of policy, that this was a policy decision, as if this gets them out of the realm of administrative action. We respect that they are mistaken in that regard, and we refer to the distinction which the courts have drawn between broad political policy on the one hand and narrow administrative policy on the other. That distinction was made clear by the Constitutional Court in Permanent Secretary Eastern Cape versus Edu College. We've given you the reference in 5.14 of our note, where Justice O'Regan said the following at paragraph 18. She said, "It should be noted that the distinction drawn in this passage," she had just quoted from the Constitutional Court's decision in another case. She says, "It should be noted that the distinction drawn in this passage is between the implementation of legislation on the one hand and the formulation of policy on the other. Policy may be formulated by the executive outside of a legislative framework. For example, the executive may determine a policy on road and rail transportation or on tertiary education. The formulation of such policy involves a political decision and will generally not constitute administrative action. However, policy may also be formulated in a narrower sense, where a member of the executive is implementing legislation. The formulation of policy and the exercise of such powers may often constitute administrative action." That fits perfectly the scheme of the present case. The executive took the broad policy decision that there should be a migration from analog to digital. It is the minister who implements that decision in terms of her powers under the Digital Migration Act. If we are correct, then the decision is administrative in nature, and it means that the PAJA is the applicable legislation and the duties of consultation are thus accordingly attracted. So what we would submit respectfully is that at every turn the minister is plainly mistaken. We submit, however they seek to classify the function, there was a duty to consult, and we have demonstrated, we submit, that such endeavours as to consultation, particularly in the absence of critical information, could never be the kind of consultation that was required. So to bring this argument together, we submit the following emerges. The facts demonstrate that there simply was no proper consultation with interested and affected parties. The Minister claims she was under no duty to consult because her decisions were executive. As a matter of law, she is mistaken. The Minister's reliance on the source of her power, being the digital migration policy, is also unsustainable as a matter of law, and hence a further material error of law. We therefore conclude that the Minister was under a duty to consult and to consult properly, and she failed to do so. And the result is that her decisions are vitiated. Can I then turn perhaps to my final topic, and that is the question of relief.
Mr. Marcus, before you do that, just two questions from me on consultation. The first is whether the 2015 amendment of the policy which deleted the consultation with broadcasters so that the ASO would only be determined in consultation with Cabinet, whether that plays any part in your argument. And the second question is, what was me make of the facts around starting on the 8th of February with the meeting convened admittedly at the last minute and all the rest of it, which preceded the SONA announcement of 31 March as the anticipated turn-off date? Because, you know, from the 8th of February with that meeting where Annexure AA7 is presented, which to me does seem to be a fairly detailed draft plan of all the different analog transmitters and how many households they serve and where they are, and the provincial chunks, I think is what it's called, that they will turn off. And then we get SONA announcement by the President of 31 March. I'm just trying to understand what role, if any, everything that happens before the flurry of September letters plays in the argument around consultation. So let's say from the 8th of February through the SONA announcement of 31 March as a target, and then everything in February and the middle of the year until we get to the September letters. Do they play any role in your argument?
Yes. Thank you.
Mr. Marcus, before you answer, please, everyone who is listening, there's interference there. Please, all the other people switch any gadget off. There's interference. Council has to speak, the judges have to speak, and if there's interference, council can't hear the judge can't hear council. Please switch off whatever other gadgets, and thank you. Mr. Marcus, you may proceed. Thank you.
My Lord, I'm indebted to your Lordship. Let me answer both of these questions. The first is what, if anything, is to be made of the deletion of the phrase consultation with broadcasters from the 2018 amendment. My lady, respectfully, nothing. Because if it goes back to the ancient origins of the right to be heard or the duty to hear. If, as a matter of fact, a decision is about to be taken which potentially prejudicially affects the rights of persons, then the law imposes a right to be heard. So the presence of consultation with broadcasters, or perhaps more particularly his absence, as a matter of law is neither here nor there. The second question is the impact of really what happened from 8 February last year to the SONA announcement of 31 March, or the anticipated date of 31 March. Respectfully, it is a matter of some bewilderment that the process does appear to have all the hallmarks of a fait accompli. That date of the 31st of March couldn't have been included in the President's SONA address by accident. Our Minister is a member of the Cabinet. There must have been input from the Minister, and at a minimum, it demanded some sort of explanation. If the process of consultation was a genuine one with an open mind and not being presented as a fait accompli to ETV or anybody else. So we do accept that there is some significance there.
So the argument would be something like the presentation of AA7 3 days before the country is told that we're targeting 31 March, that that meeting convened at the last minute, and obviously we've seen the account in the affidavits of what happened at the meeting. You would say that 3-day period, insufficient, not meaningful consultation, it's the fait accompli that was presented on the 8th, announced on the 11th, not meaningful consultation before the announcement, if the SONA announcement is to be given any sort of significance as opposed to the gazetted date.
Correct, my lady. You have our submissions. Can I then turn to remedy? And let me deal immediately, this is in paragraph 6 of our references document. Let me deal immediately with ICASA's concerns, and I do so to get it out the way. Our learned friends for ICASA in their heads raise arguments that ETV is not entitled to any order. ETV is not entitled to any order in respect of ICASA. They say that throughout their heads, and I think we give you the references in 6.1 of our note. But respectfully, our learned friends either misconceive or misread ETV's papers in this regard, because neither in the founding papers nor in the replying affidavit, nor indeed in our heads of argument, is any relief sought against ICASA, either directly or indirectly. The relief which is claimed is directed at the minister. And ETV, in fact, made that point explicitly in its replying affidavit at paragraph 117, and we've given you the reference. Now, our learned friends for ICASA don't indicate on what possible basis it can be said that any relief is sought against it. And once it is clear that no relief is sought against it, it appears that its opposition largely falls away. And so in that regard, we respectfully submit that such concerns as ICASA might have are not sustainable. The relief we seek is of 3 kinds. It's declaratory relief, review relief, and reporting relief. Let me start with the declaratory relief. That's prayers 2 and 3. The arguments we have advanced in relation to the failure to consult and the unreasonableness of the minister's precipitous conduct in relation to digital migration and the date of the ASO, we submit demonstrates acutely why declaratory relief is appropriate. It is especially appropriate now that council, on behalf of the minister, take the view that there is no duty to consult at all. There is a suggestion from both the minister and Vodacom that the relief sought impermissibly trenches upon the separation of powers. That, respectfully, is simply wrong. It is also something of a tired argument that is routinely trotted out when the state wants to escape its constitutional duties, and we have seen this many times before, and the case law demonstrates precisely why this is wrong. Let me just give you a few examples to demonstrate the point. As a prelude to what I'm about to say, the relief which we seek is pursuant to section 38 and section 172 of the Constitution, both of which plainly envisage declaratory relief. But let me address the separation of powers argument. For example, in the Glenister case, and we've given the reference in 6.4 of our note, the Constitutional Court emphasized, and I quote, "It is a necessary component of the doctrine of separation of powers that courts have a constitutional obligation to ensure that the exercise of power by other branches of government occurs within constitutional bounds." In other words, far from this being an abuse of the separation of powers, the Constitutional Court has indicated that the very doctrine which our learned friends for the Minister and Vodacom invoke on occasion imposes an obligation on the courts to declare that conduct is not within constitutional bounds. In Khumbulo's case, again referenced in 6.4, the court put it this way, and I quote, "It is the duty of the courts to insist that the state, in all its dealings, operates within the confines of the law, and in so doing remains accountable to those on whose behalf it exercises power. The supremacy of the Constitution and the guarantees in the Bill of Rights add depth and content to the rule of law, and perhaps most importantly is the treatment action campaign case. And the court will recall that what was at issue there was the implementation of a policy by the state under the aegis of the Ministry of Health to limit the access of an antiretroviral drug called nevirapine to various selected sites in circumstances where the then Medicines Control Council had registered nevirapine as a drug which was effective in preventing the transmission of HIV from mother to child during birth. And the argument advanced by the state in that case is identical to the one advanced by our learned friends for the Minister here and by Vodacom, and it was emphatically rejected by the Constitutional Court. The court said in the TAC case at paragraph 99, "The primary duty of courts is to the Constitution and the law, which they must apply impartially and without fear, favour or prejudice. The Constitution requires the state to respect, protect, promote and fulfil the rights in the Bill of Rights. Where state policy is challenged as inconsistent with the Constitution, courts have to consider whether in formulating and implementing such policy, the state has given effect to its constitutional obligations. If it should hold in any given case that the state has failed to do so, it is obliged by the Constitution to say so, insofar as that constitutes an intrusion into the domain of the executive. That is an intrusion mandated by the Constitution itself." So respectfully, the arguments on separation of powers are old arguments. They've been rejected by the courts. I don't for one moment suggest that a court should ever be oblivious to the separation of powers, only that that argument has no place on the facts of the case which is before the court. Then there is the review relief, which is prayer 4. It entails the absence of proper consultation around the ASO date, and in circumstances where, as we have submitted, there is a right to be heard and there is a failure to afford a proper hearing, then the courts have indicated repeatedly that the entire decision is vitiated. We give you several of those authorities, both pre-constitutional and post-constitutional, in paragraph 6.5.1. Pre-constitution was the well-known case of Administrator Transvaal versus Zemzile. We've given you the reference in 6.5.1, but it is worth quoting, if I may, where the court said this at 37. The court said, "It is trite, furthermore, that the fact that an errant employee," that was a question of the dismissal of an employee from public service in that case, "It is trite, furthermore, that the fact that an errant employee may have little or nothing to urge in his own defence is a factor alien to the inquiry whether he is entitled to a prior hearing." And they then go on to cite Wade in that regard. And the court then goes on to quote a dictum from an English case called John versus Rees, which has been repeatedly now adopted by the Constitutional Court, but is critical to a proper understanding of this case. In that case, Justice McGarry said, and I quote, "As everybody who has anything to do with the law well knows, the path of the law is strewn with examples of open and shut cases which somehow were not, of unanswerable charges which in the event were completely answered, of inexplicable conduct which was fully explained, of fixed and unalterable determinations that by discussion suffered a change." That encapsulates the benefit and the obvious need for proper consultation. I go back to what I said earlier. That is not simply in the interests of those who are affected by the decision in question. It is equally important to ensure that the decision maker is properly equipped with the facts to make an informed and accurate decision. Then there is the reporting relief. Let me say immediately that we accept that reporting relief is exceptional in the sense that it is not usual. And the real question before the court is whether it is warranted on the facts of this case. Let me preface what I'm about to say with the following. To my own knowledge, the Constitutional Court has on occasion actually imposed reporting relief in circumstances where it hasn't been requested by the parties. So the competence of reporting relief respectfully is beyond debate. The only question which your ladyships and your lordship need to consider is whether this is a proper case for reporting relief. So let's look at the state of play. We know that the minister was invited to file an affidavit setting out how many STBs had been installed and how many more households had registered and definitely required STBs after the 31 October cutoff. The minister failed to do so. The minister in the present case denies that she is under any duty to consult at all. The switch-off date, now a mere 2 weeks away, will result in very large numbers of South Africans being unable to access digital broadcasts, thereby denying them their constitutional rights. This will occur in the face of repeated promises that this will not occur, and it is a breach of those promises. So we submit this is an obvious case where reporting is justified. It is a case, like many others where reporting is being imposed, where large numbers of South Africans are in imminent threat of violation of their rights. That was the position in the Treatment Action Campaign case. It was equally the position in August versus the Independent Electoral Commission, which concerned the rights of prisoners to vote, and it was likewise the case in Black Sash, which concerned access to social grants. And this is a case where, for all the reasons we have advanced, the minister has not only been, we submit, oblivious to her constitutional duties, but indeed on the argument advanced by our learned friends, now goes so far as to even deny her constitutional duties. So on this score, we submit that the All Pay 2 decision, which was the prelude to the Black Sash decision, and it was the case in which the court first imposed a reporting obligation, really captures the same problem that we have here. The constitutional, this is in 6.6 of my references, the court noted, and this is in All Pay 2, and I quote, contrary to the obligations it carries under section 195, SASSA has adopted an unhelpful and almost obstructionist stance. It failed to furnish crucial information to All Pay regarding the implementation of the tender and to Corruption Watch in respective steps it took to investigate irregularities in the bid and decision-making processes. Its conduct must be deprecated, particularly in view of the important role it plays as guardian of the right to social security and as controller of beneficiaries' access to social assistance. We submit respectfully that this is an R40 case. The Black Sash case, which is referenced in our heads and in our note, goes into greater detail as to the circumstances in which reporting is justified. We submit that the present is such a case.
Mr. Marcus, just a practical question from me about the effect of the declaratory relief in 4. And given the fact that the case was launched in October, presumably your client doesn't imagine that the 5 provinces that have been switched off are turned back on.
No, I don't suggest we can reverse history. Okay. Justice LaRue, I think you foreshadowed that question earlier, if I'm correct, and I forgot to answer it. There wasn't a further question which you had, or am I mistaken?
No, that was
the question.
Was it? Thanks.
So my ladies and my lord, those are my submission. I have only 2 final things to say. The penultimate thing is the ever-present question of costs. In our heads, we've asked for the costs of 3 counsel where employed. And one final matter, which is a personal matter, I must in conclusion request that I personally be excused from the hearing tomorrow due to an unexpected set down in another matter. I obviously have cleared that with my own client, but I give you the unequivocal assurance that your ladyships and your lordship will be left in the capable hands of my learned friend, Mr. du Plessis, and I would appreciate that indulgence. Those are my submissions.
Thank you. You may proceed.
Thank you, Mayor. I think Justice Msimang, you're on mute. I'm not sure if you were speaking.
No, I thought I was speaking, but because I could hear those interferences, I switched off. But nonetheless, you can proceed. I meant to tell you to proceed.
Thank you, my lord, my ladies. The first point which I must address is the question of my client's intervention application. I've ascertained from my learned friends on behalf of ICASA and Vodacom that neither ICASA nor Vodacom opposes the application for intervention. However, I understand that the Minister continues to oppose the intervention application on the basis set out in the Minister's heads of argument. So I must address it briefly at the outset. Justices, our submissions on this issue are set out in the heads of argument at paragraph 20. We submit that the test is essentially the same as the test for whether my clients would have standing to bring this application and seek the relief that they seek in their own interest and independently of ETV. That test we submit is plainly satisfied in this matter. My clients are entities with a long history of activism and litigation in the public interest on the issues relating to broadcasting, and in particular the role of broadcasting as it pertains to the expression rights of the indigent. And we submit that on the authority of the Black Sash case, which dealt with a similar intervention on behalf of NGOs in order to protect the constitutional rights of those whose interests those NGOs represented, what the SCA held there was that where an intervention of this nature comes in the public interest, it should manifestly be granted. And I should say in conclusion on the test for intervention that it seems from the Minister's affidavit that the Minister simply applies the wrong test. She invites this court to ask whether my clients add any material in addition to that which is provided by ETV, which is useful. That is the test for an intervention by an amicus curiae who seeks to come in as a friend of the court. That is not the test for intervention as a co-applicant, which is what my clients are. The test there is whether there is a direct and substantial legal interest entitling them to intervene in the application, and we submit that test is plainly satisfied on these papers. Justices, the final thing that we wish to say on the intervention application is that the intervention brought by my clients fundamentally changes the way in which this case ought to be characterized and can be characterized. There's an attempt in particular by our learned friends for Vodacom to characterize this case as really a commercial squabble which has been dressed up in constitutional clothing between, on the one hand, ETV, which is a commercial broadcaster, and on the other hand, Vodacom and its associated network operators who seek to benefit from the spectrum, which is an issue. That characterization cannot be accepted on my client's intervention because we bring a broader perspective into the case, and in particular my clients exist in order to give voice to those indigent millions who rely upon free-to-air television broadcasts in order to protect their expression rights. And we cannot be accused, as ETV has been accused, of seeking to delay analog switch off at any cost for their commercial benefit. In fact, what you see from my client's replying affidavit from page 019 to 212 is that my clients have a long history of engaging with the state on the issue of the spectrum and digital migration. Those engagements have not been designed to delay and to secure further dithering on the part of the state. In fact, many of those interventions by my clients have been attempts to move government along because my clients recognize that it's important that spectrum be freed up. They recognize that it must be done swiftly. And so we are really at idem with our learned friends about the destination. The destination is that we must get to a point where analog broadcast is turned off and that spectrum is freed up for use by the network operators. We all agree about that. What we disagree about is what method of implementation may permissibly get us there. In other words, by what route may we get to that end point whereby the digital dividend is realized. And what my clients say, and for the reasons we will explain, is that you cannot reach that outcome, no matter how beneficial, by violating the expression and information rights of millions of indigent South Africans. We have to follow a process which brings all of them along in the process of digital migration, and we will explain the various respects in which we submit that has not been done. So that is the intervention application. We submit there's no serious or there's no sustainable basis for resisting it, and my clients should be intervened as co-applicants to seek the relief in their notice of motion. My lord, my ladies, if I may move on to my second point, and that is on the facts. I've got two factual submissions to make. The first is to ask the question, how did we get here? In other words, how did we get to almost the end of March with a date of analog switch-off set for the end of March in circumstances where on the papers it's apparent that there are millions of indigent South Africans who have either registered and not yet have their set-top boxes installed, or who have not yet been able to register. And those facts are important. And then the second, and this is the one which engaged the debate between Mr. Marcus and the court earlier, is the question of the numbers. What do we know on these papers about how many require set-top boxes, how many have them, and how many have registered and already been installed? And I'll go into that issue in some detail. So to briefly address the first question, how did we get here? This is addressed in our heads of argument at paragraph 10. And what that paragraph sets out is quite a long history, particularly between the years of 2005 and 2020. That's a 15-year period, during which time the state was busy talking about and working towards digital migration, which is something that culminates in the switch off of analog television broadcasts. There were various sets of regulations that were enacted, and in 2008, the 1st of November 2008, the period of dual illumination commenced. That's the period during which time there were both digital broadcasts at the same time as analog broadcasts. And so this is the transitional period. And there was a series of failed targets for analog switch-off. And the first was that the state aimed for November 2011. For various reasons, that date was not met. Then they aimed for June 2015. Again, that date was not met. And then there was a long period of state, let me not call it inaction, but there was nothing concrete that was done to tell the public that you need to be aware that there is a cutoff date coming and you need to take action to register yourselves during that time. Then, on 11 February 2021, something significant happens, and that is the date on which the President gives the State of the Nation address, and the President tells us that analog switch-off will be completed by 31 March 2022. That was still a year in advance of the switch-off date. And so at that time, there was still time for the state to conduct a massive campaign to get people to register. They could at that time have said to people, you will need to register by the end of October in order to qualify for the set-top box. There was still time to accelerate the installations process at that time. But it doesn't happen at that time. And again, there's a long period, about 7 months, where in relation to communication to the public and the attempt to communicate a cutoff date by which people are told that if you don't register by this date, you're going to lose your access, nothing really happens. And the next action that really happens is in paragraph 10.19 of our heads.
Mr. Ferreira, on that score, in 2021, there actually was a plan which indicates that provinces were allocated for such top boxes, and I think it shows province by province. They were switching them off, and it was meant to go on until I think December or January, ending up in Gauteng. And it would appear that during that period, that's when some registration took place, and that's when the other provinces were being cut off. So that plan seems to have been there. Are you aware of that?
Yes, Justice, and I should add that the submissions I'm making are not made from the position of a broadcaster who claims not to have been consulted about the contents of the plan. When I say little happened of a concrete nature, what I'm referring to is communications to the indigent television watching public to be told that you need to take action to register yourselves. And I'm not saying there was nothing. Throughout that period, there was a campaign informing people registration needs to take place. But the end point of my submission is that we come to the 5th of October 2021, and there, without warning, and for the first time, indigent television watching households are told by the Minister in an announcement that you now need to register if you need support to get a set-top box, you need to register within 3 weeks from the date of this announcement in order to qualify, in order to avoid falling outside of the cut-off date. And if you do fall outside of the cut-off date, you will inevitably lose access to free-to-air television for a period of 3 to 6 months. So it suddenly accelerates at the end of September 2021. That's 7 months after SONA. And during that month, the Cabinet approves the BVM and ASO plan. That's in paragraph 10.19 of our heads. And then on the 5th of October, the Minister issues this statement. Now, if I may ask the Court to go to the statement, because it's fairly critical in assessing the rationality of the process which the Minister chose to follow. I will try to direct the Court using case lines to that document. It's at page 001-214. It's a media statement issued by the Minister. It is dated 5 October 2021. And what it says, essentially, insofar as it is a communication to indigent television watching households, it says a number of things of relevance, but the most critical thing it says at paragraph 4.1 at page 001-217 is it repeats the promise that we, that is the state, have to ensure that everyone who needs to migrate from analog to digital is ready to do so and are not negatively affected by a switchover from analog to digital. That's 4.1. Then 4.2, it says South African citizens who are still reliant upon the analog services by using an aerial or antenna should find themselves a set-top box or a smart TV.
Mr. Ferrier, can I just interrupt you? If we could just ask people that are joining us on the link not to use the chat function as if it's a comment box on a YouTube live stream, please. This is, you know, the chat function will be part of the court's transcript. So if we could just have a bit of restraint on using the chat function, please.
Thank you, Meridian. Perhaps I should suggest if the registrar of the court is able to, that functionality can be switched off on Teams. Milady, paragraph, and Miladies and Milord, paragraph 4.5 then deals with households qualifying for support. And I'm going to come back to this statement in relation to the numbers. I'm not addressing the numbers at this stage. It says that Cabinet has approved a last call for registration with a cut-off date of 31 October 2021. And those who don't make that 31 October 2021 date will only be connected within 3 to 6 months after analog switch-off. So this is, insofar as it's a communication to indigent households, this is the first time that you are told there will be a hard cut-off. That hard cut-off is going to be 3 weeks in the future, in other words, end of October 2021, and you either need to get to a post office and register, otherwise you will be plunged into a television blackout for 3 to 6 months after analog switch-off. Now, what we submit is that this step in itself infects the entire process which leads to the determination of the date as the end of March with irrationality, unreasonableness and disproportionality. Because what it does is it imposes a sudden, strict cut-off date for 3 weeks in the future in circumstances where it's preceded by literally decades of government dithering. And the reason for that is not apparent on these papers, and the result is what ETV and the interveners have called the rush towards the March cutoff date, and it has resulted in a chaotic shambles in which huge numbers of indigent households have not been able to comply with that 3-week deadline. Unsurprisingly, a 3-week deadline is a very strict deadline in a country like ours. It's going to be hard for anyone to comply with it, particularly indigent South Africans. Now I'll just give you an illustration of the shambles which this statement involves. If you look if you look at paragraph 4.5.2, you see there it says we call upon all eligible households to register at the nearest post office on or before the 31st of October to receive government assistance for STV installation. And then it says we are also finalizing a registration app and the details will be announced in the near future. Now that sounds quite helpful. If you can't easily access a post office, using an app to register electronically as an indigent household seems like a good idea, and it seems like an attempt to facilitate speedy registration in time for the end of October cutoff. But unfortunately that app then disappears from view. We don't see any mention of it again. But then if one goes to page 019-210, this is and I'll again direct the court there. This is another media statement by the same minister. Sorry, just repeat where you say on case lines. It's 019-210.
Thank you.
This is the minister's media statement, and the date is significant, 24 November 2021. So this is a media statement which is issued after the cutoff date. So if you, by the time this statement is issued, it's too late for you to register in time to get a set-top box in order to avoid analog television blackout. But what we find in this affidavit at page 019212, it's confusingly paragraph numbered 1, and here we have the minister's updated statement on how to register electronically. No longer is it an app, there's now a website. It says for indigent households, government assistance is available through registration at your nearest post office or through the following link, www.stvregistration.gov.za, as from Monday 29 November 2021. So 1 month after the cut-off date for registration for assistance to obtain a set-top box, government's, more than 1 month, government's website link to allow indigent households to register is going to go live. And that is just one small example of the shambolic way in which the minister has approached this rush towards the end of March. Anybody who wanted to register using the government link by this time has missed the boat. They can now register, but they're going to be plunged into a blackout with effect from the end of March unless this court intervenes. So our submission, my lords, my lady, is that combination of a rush right at the end of the process and the sudden decision on the 5th of October to impose a hard deadline of the end of October means that indigent households were not given a reasonable opportunity to register for assistance timelessly. And the result is that we are looking at millions and millions of people who are going to lose their access. And that's the point I want to address next. This is the question of the numbers. So these are the critical facts which are established on these papers. Firstly, that free-to-air television is the primary mechanism of receiving information for many millions of indigent households. The reference for that is set out in paragraph 10.1 of our heads of argument. And the question then is, how many millions are we speaking about here? Now,
Mr. Pereira, how do we know that? I know that the allegation is made in the reference to the founding affidavit. And we know that, obviously, everyone keeps saying it's important and it is an important mechanism through which people get information. How does the court know through evidence rather than assertion that is right?
Maybe if one looks at the founding affidavit filed by my clients, what one will find is that it is explained in some detail that for indigent households, the primary source, and I'll just find the reference for your leadership, the primary source of a range of different kinds of information is free-to-air television, and it is also explained why that kind of information is not available through other channels. And so what we're talking about here is when one looks at the Broadcasting Act, every free-to-air broadcaster is under a range of duties to provide certain kinds of content in the program. That content includes public service announcements, political advertisements, educational material. The entire statutory regime of broadcasting is designed to force broadcasters to provide South Africans with that kind of material.
No, I'm aware of all of that. My question is, I mean, let me maybe put it more bluntly, and admittedly, I may have missed it in the papers when I was going through them. I mean, for example, do we have stats on viewership of ETV, viewership of SABC, viewership of free-to-air DSTV before it fell off? I mean, do we have that denominator of all free-to-air viewership that we could then try to work out whether the numbers in the minister's media statement in October would be the a subset of that overall, how many people actually watch free-to-air TV?
Yes.
Then we would be able to work out whether the numbers given, this 3.7 million households, the 8 million individuals, we would have a sense of, like, does that seem to match viewership numbers? I don't know if your clients in their monitoring role, I perhaps should have asked Mr. Marcus, because I'm sure the advertising department at ETV knows how many eyeballs they get. Do we have a sense of that, the viewership of free-to-air, and then we could work out how many of them are indigent?
Yes, maybe we do have that, and it is not evidence which is mainly asserted. So if I may take the court to page 005-33 of my client's founding affidavit, what the court will see from 005-33, I'll direct the court there. And this is under my heading of how many people need assistance in being, how many people need to be migrated to a set-top box. This is the answer to that question. What you'll see is that my client refers to the Television Audience Measurement Survey, which is carried out by the Broadcast Research Council of South Africa. According to that research council, there are some 15.8 million television households in South Africa, which covers the vast majority, more than 90% of the population. And I'll go on to explain to your ladyship that there is an affidavit by the CEO of the BRC confirming these particular figures. Then what is said in the following paragraphs of this affidavit is that some of those television households, about 47%, have access to subscription broadcasting services through DSTV, so you can strike a pen through those. Those are not households of concern. And then there are a few other sources by which one can obtain that free-to-air broadcasting without receiving an analog signal. And those are all again cut out. But in paragraph 62 on page 005-34, what we say is that the bottom line is that according to the Broadcast Research Council of South Africa, 36%, more than a third of the population of 5.7 million households, rely entirely on analog terrestrial television services to access FTA television, and only 17% of the entire population has access to free-to-air TV services on digital services. And
but we don't know how many of the 5.7 million are under 3,500 a month.
No, exactly, Milady. So, and that's what and that's why everyone has to rely on what the minister says in his statement. And there is no better evidence than that. And I will make some submissions on that. But insofar as the number of indigent households who need assistance, one has to rely on the minister. There's nothing better than her statement. And Milady, may I just say, in relation to this material, this evidence from the Broadcast Research Council of South Africa, the minister does not dispute these allegations and does not deny them. You don't have to go there, but the reference is the answering affidavit of the Minister at page 013-6 at paragraphs 18 to 24.
Mr. Pereira, I think what my sister is asking is what we've been trying to ask even with Mr. Marcus, is that the minister has relied on statistics from Stats SA, and we don't know if those statistics were specifically compiled for the issue beforehand, or those were statistics which were compiled to show how many households in South Africa and below 3,500. Because if it's taking on those bases that these are families in South Africa who live below 3,500, it doesn't really address those issues. And we cannot say if those statistics are reliable. That's the first thing. The second thing, insofar as that is concerned, is that those statistics are statistics of 2018. What is the position now? Can we rely on those statistics today? Because they seem to be outdated in any event. We don't know what the statistics are now. And that's how the minister worked on those, and ETV also worked on those statistics. And that's where the problem comes in. Don't we need a reliable report that tells you how many households are there, how many households are good? Someone must have compiled that report. We don't have that report. So these projections, at the end of the day, are made on statistics that cannot be verified. Are you able to help us in that regard?
Mr. Ferreira, before you start, if I can just add to your listener, and I'm sure this is feeling unfair because these are all questions for Mr. Matau, but I'm sure he's listening closely as well. Just to get your submission on whether the 1.45 million set-top boxes is a useful denominator of anything, and whether the number of registrations is a useful indicator of how many people we're dealing with.
Thank you, Milady.
Let me just add so that you can include this in your answer. ETV, I know that you are not answering for ETV, but for yourself it's in general. ETV had a number that they did a measure of how many people are still watching analog on for their channels.
I just lost my sister.
Yes, Milady, I seem to have lost the third member of the court too.
Did somebody turn off a digital band and not tell us?
From the meeting.
You're back. No, you're back.
Yes, but I just got a note that said someone removed me from the meeting. So is it a number that all the other broadcasters are able to get for it if we are really trying to find out how many people are still using analog? Because ETV seems to have the number at like 500,000 or something in their papers to say that they did a measure, I think up to October 2021 or something like that, and 500 and something thousand of their viewers are still using analog. So is it something that can be, is it a number that can be ascertained to say these are the number of people that are watching through that?
Thank you, Lily. Maybe if I may deal with Judge Msimang's questions first. Justice Msimang, we do know that the 2018 Stats SA count of indigent households will no longer be accurate, and that's why Stats SA is conducting a new census. What we know from the papers is that, if anything, there will now be more rather than fewer indigent households. That is common sense because we know we've been through COVID and the July riots and the general contraction of the economy, but it is on the papers. It's pleaded in at page 005-38, paragraph 75 of my client's founding affidavit. So we know that that 2018 figure is out of date. But that does not rebound to the benefit of the minister, because we know that there will now be more indigent households requiring assistance than there were in 2018. The second point is, in addition, yes, somebody ought to have conducted a study as to how many people were going to be plunged into television darkness as a result of the end of March date, and that somebody is the minister. And so, again, it doesn't help the minister to say, yes, I said in my statement there are 3.75 million indigent households. In order to take a rational determination as to the date of switch-off, it was for the minister to go and conduct an investigation as to how many people would be affected and in what way. And I will make submissions in due course that her failure to do so, far from constituting a defense in the hands of the minister, actually demonstrates beyond any question that the decision was not rational, because she failed to take into account a relevant consideration, namely the number of people that would be plunged into television darkness as a result of her decision. Justice LaRue, to deal with your question about the registrations and the number of set-top boxes that have been installed, I'm going to say a little bit more about those, but those are a helpful proxy in order to determine how many households need set-top boxes and manage to comply with the 3-week deadline in order to register for those set-top boxes. And we do know that quite significant numbers registered. By the end of October 2021, it was 1.2 million who had registered, and that had increased, I think, by about 60,000 by the end of November 2021. But it is not an adequate proxy for a proper determination because of the unreasonable process which the minister followed. Because of that unreasonable process, we know that there are households out there who need assistance, but who would not have been able to make it to the end of October deadline, and so they remain out in the cold. So that takes me on to the second factual question in relation to the numbers, which is how many of those who need have registered. And I've submitted that we know that from the MMA founding affidavit, about 1.2 million had registered by the end of October 2021. If one then deducts that from the 3.75 indigent households number, what one gets to, and this is where the 2.5 million that is stated in the papers, about 2.5 million households or 8 million individuals who would have needed assistance to migrate, but were unable to register in the time available. Now, what we are told in the papers by Vodacom and by the minister is, don't worry, some of these people will have self-migrated. And the minister says, look, when you drive past the township, you see all these satellite dishes on informal settlements, and so you can assume huge numbers of people have self-migrated. But there is simply no proper determination or investigation or scientific attempt to determine how many people have self-migrated, how many need assistance, and how many fail to meet that unreasonable 3-week deadline. So,
I think that my sister is asking you, the question that we're asking is that there's the registration, or when people register themselves, that is a more realistic figure we can work on, because people went there to say, I require the set-top box. And then we cannot then take that figure and say if 1 million people have registered, how many houses are at income below 3.5? And then we say it's 3.5 million. Then we go and deduct from the 1 million that have registered and say then the rest who have not registered, the rest of the people who have not registered, the 2.5 million, then it means those people do not have coverage. It's a very, very dangerous place to tread on, because we just don't have the figures. In fact, my sister is correct. The people who registered really should be considered to be the people who are indigent, because they've taken the effort to go and register. And the 2.5 million that have not registered, we just assume, not unless you've got a report that has been compiled specifically by an expert who's going to tell us this is the position. Otherwise, we second guess it. What do you say to it?
Justice.
Before you answer that, can I just check my understanding of your argument thus far, Mr. Ferreira? You are saying because of all, even after the 5th of October, because of the kind of arrangements that were in place from the 5th of October to the 31st of October that were less than desirable. That is precisely why even those people that have managed to register can't be an indicator of the need, because so many people were left out of the information on the need that at least on one account there was no place for them to go, and there was supposed to be an app, it's not there. A month later, they were referring to a website that was still supposed to be set up. So you are saying, and because the app was also announced on the 5th of October as something that's coming, other people might actually have sat back and waited for this app to come, and it never came. So that is why even the people that registered between 5 and 31, if I'm following your argument, that is why that number is not also a representation of the need.
Exactly. If the process followed by government to allow people to register timelessly had been a reasonable process that afforded them a reasonable period of time within which to register, and the government was set up, for example, by having its registration website ready, having the app ready, and people had a reasonable opportunity to do so, then we could take registrations as a proxy for those who need. But because government's process was not reasonable, because it gave a 3-week deadline suddenly on the 5th of October, one simply cannot assume that all those who need help manage to register within the time available. That's precisely the solution.
And then, Mr. Ferreira, just building on my sister's question, 2 questions. One, does the fact that the registration window remains open, how does that change this question for us? I know that we'll hopefully be getting a supplementary affidavit in 40 minutes that tells us something about registration post 31 October. Second question, given that we're on application proceedings and everyone uses the 5 October media statement figures, on Plascon Evans, surely that plus this new affidavit is as far as we can go. So if we decide that the evidence is insufficient, where does that leave us?
Yes, Mary. May I also answer the second question first? If one goes to page 001215, this, and again I'll direct the court there, at paragraph 2.1, this is where the minister explains the facts that she took into account in determining, well, that's not what she's doing. She's making a press statement. And what one sees from that press statement is what the minister thinks are the numbers. And it is in reliance upon the minister's public statement as to the numbers that the applicants come to court. And so paragraph 2.1, she says that 1.184 have been registered out of the estimated 3.75 million qualifying households. And that's the, as I say, that is the best objective evidence that there is. But that's not a point in the minister's favour. It's a point against it, because if it turns out, as Justice Musimang is putting to, that number is suspect or inadequate, far from rescuing her decision from irrationality, it renders it irrational. And the second question, Justice Marie, that you put to me relates to my conclusion, which is that there are really two separate categories of persons of concern here. Firstly, and this is what we've primarily been debating, are those who have not yet registered, but who do need assistance. And that's where this question of the 2.5 million households, the 8 million individuals comes in. On the best we can figure from the minister's numbers, there are 2.5 million households and 8 million people who have not registered at all. That's the first category of person of concern. But we mustn't be heard to suggest that the second category is not important. In fact, they're just as important. These are the numbers of persons who have registered, either before the cut-off date or after the cut-off date, but who have not yet been installed. Because it's no good to have registered but not have a set-top box installed. If that's your position, you are going to be plunged into television darkness come the end of this month. And insofar as the second group is concerned, what we know is that there are some 660,000 households who are registered. In other words, they've stuck their hands up, they have complied with government's process, they say they need a set-top box, they have not yet had their set-top boxes installed. Now, we know in relation to those that it's likely going to be, at the very best for the minister, a period of 3 to 6 months before they manage to get installed. They will be in television darkness for the whole of that time. And 660 households represents some 2 million individuals. And we know also in relation to the existing installation process that has taken place up until to date, that at the end of October 2021, there were 556,000 installations that had occurred. We know that from the Minister's affidavit in page 00971, paragraph 230. That took 5 years to achieve. We know that some of those who applied to be registered at the outset have not yet been installed. In other words, at the very beginning of the process, some of these people did what the Minister said. They went and they registered, they properly registered, but they haven't yet been installed. And we know that because the Minister, in one of the press statements, says so. They say, this is at page 019-244. In fact, this is a post office media statement. And the post office says, the SA Post Office is aware that some families registered for a set-top box at the beginning of the campaign, but the installation has not been done yet. Installations are done per province, and appointment of local installers is done by Centec via local municipalities. There's no need to re-register to make sure you receive. So, and this is on 21 October 2021. There are some who have registered who have not been installed, and so we submit. You cannot believe the Minister when she says, if you come after October but you still register, it will be 3 to 6 months. That is not realistic on what we know from the facts. We know that there is a massive chip shortage when it comes to manufacturing new set-top boxes. We know that the post office is in a dismal state. We know that there are not enough installers to do the job, and we know that it took 5 years to do 550,000 before, up until now.
Mr. Pereira, just 2 questions on that submission. The Minister's answer to one of your points is there are 800,000 sitting in a warehouse that can be deployed. Just your reaction to that. And then So on the chip shortage supply chain issue, she says there are 800,000 ready to go. And then, again, this is unfair to you because it's a question for Mr. Matau and hopefully the affidavit as well that's arriving is, why 3 to 6 months? Given that we also see on the papers, 6,000 installers doing 4 to 6 boxes a day, why does that take 3 to 6 months when if you do the maths, it's a couple of days?
Yes, we will await the further affidavit with interest because it may have evidence of a massive acceleration of speed of installation and maybe 200,000 were done in the last week.
When you say we don't have enough installers, I understand there was a point where the contract was cancelled and all of that, but the minister now in these papers says I've got 6,000 installers.
Milady,
so again, we have to accept her version on Plasco and Evans. If she's got 6,000 ready to go, who can do 3 to 6 a day?
Yes, but one also has to look at the rate of installation that is actually being achieved, because it's all very good and well to have good intentions, and it's good and well to have 800,000 sitting in a warehouse to satisfy demand. But as up until to date, it has been installation of those who have registered that has caused the significant bottleneck. And what we know is that in the month between the end of the deadline and November, when the minister filed the affidavit, there were 60,000 that were installed. Now, that is a rate which is not going to achieve 660,000 in 3 to 6 months. And again, we'll have to see in the update that we're going to get in half an hour whether that has been improved upon. But we doubt it, and we don't say it's because of bona fides or lack of a desire to leave people out in the cold. This is a practical problem of taking an electronic item out to somebody's home and installing it, and it takes time. And we just all have to be realistic about that, including the minister. So Milady, those are my submissions in relation to the numbers. On anybody's version, there are going to be millions of South Africans plunged into TV darkness for a period of 3 to 6 months at least. That there can be no dispute about on these papers, even though we made debates about which range the numbers fall into, the upper range, the lower range. It's millions of people, it's 3 to 6 months. And that, we submit, is a very serious constitutional harm. It is a very serious limitation of expression rights, and it is a very serious, we will submit, retrogressive measure. And the question in a rationality review is why? Why was it necessary on the 5th of October to impose a 3-week deadline, a hard deadline? And more importantly, what was the magic in the 31st of March? Why 31 March and not 31 April? And why not May? If that time would give the indigent time to obtain a set-top box.
But isn't the answer the spectrum auction and reallocation and
one is
of that litigation? I mean, isn't that what changed?
One is told at the general level that it is important to get there in a hurry, and the spectrum auction will benefit many, but there is no reason offered which justifies the end of March date, other than that the President announced it in the State of the Nation, and that the process was then retrofitted by the Minister in order to accommodate the date which was announced by the President. That is even clear in the Minister's answering affidavit. I'm sorry, Milady, I think you're on mute.
Yes, maybe which is something that Mr. Matau would have to assist us with, because my understanding would be that before the President says something in his State of the Nation address, the Minister would have provided information to that effect, and it goes in there, which then begs the question, which I'll then ask also to say, why then wait all this time and then only in October say something where they would have provided the information back in February to the President to say something about? So it sort of doesn't make sense.
It doesn't make sense on any rational assessment of it. and it's pleaded that that date was retrofitted to suit the President's announcement. It is in the answering affidavit, this is in the Minister's mouth, at paragraphs 243, 445, and 300, and well, let me leave it at those two references. And what one gets is no substantive justification of that selection of a date at all. We are just told that there are benefits from auctioning spectrum and that those benefits must be realized in a hurry, and South Africa is behind in terms of the deadlines, in terms of its international law commitments, but one doesn't get any explanation as to why it has to happen at the end of March, and one certainly gets no explanation whatsoever as to why it was necessary on the 5th of October to say everybody now has 3 weeks, and if you don't get anything in those 3 weeks, you will be plunged into darkness. And so
Mr. Pereira, why the rush? I don't know, but this process has been going on for a very long time. There must be a cut-off date somewhere, sometime. Why the 21st of October? Probably, I don't know, your guess is as good as mine. Probably because they wanted people to go and register. We all don't know that, but what's at the end of the day very important is to know that South Africa is behind. There is spectrum that must be released, and everybody agrees that that spectrum must be released. The IMT 700 and the IMT 800. ETV says yes, you can do that. We are agreeable to having it, and we must clear the runaway for that plane to take off. When, if I were to have asked Mr. Marcus, how long do you think, what time is required for this process to take place? Because the release of spectrum is the most important thing for everybody, for the operators, even the broadcasters and everybody. So the thing is, South Africa is lagging behind. And at some stage, maybe the president announced in 2021, and I suppose when he announced this year, he said 31st March. So something has to happen. How long do you think it will take to get to that point where we can all say yes, everybody will be happy, and the spectrum will be released? Because we just have to be practical about this thing. At the end of the day, we need to release that spectrum.
Yes, thank you, Justice. I think it is a critical question. One cannot speculate in the shoes of my client as to how long will be necessary to run a lawful and constitutionally compliant process. And with respect, the court should not speculate on it either. That is a question for the minister. And one can only make the submission from the bar that it doesn't have to take months and months to give people fair notice, to allow them to register timelessly, to ramp up set-top box installation. All that we can say is that it is not permissible to rush towards it in a manner which results in millions of people being plunged into blackout. And the jurisprudential pigeonhole by which I would submit this court should resolve that question is by simply granting the review relief, which is to review the unlawful determination of the cutoff date and making clear in its judgment what the reasons for granting the review relief are, and not to try to bind the minister to some particular time period or some particular process other than to require the minister to report back as to what has been done. And that is the province for this court. This court's province is to assess the legality of executive and administrative decisions, and that is what this court should do. The minister's job is to figure out how to run a fast, constitutionally compliant process. And that is not on these papers, according to the Minister, a hugely complicated exercise. It's one of giving people proper notice, a reasonable time to register, and facilitating a swift installation of an appropriate set-top box in due course. If we're all as fortunate and we live in the world as Vodacom seems to imagine we live in, and these millions of people have all self-migrated, once that is determined through a proper study and a proper registration process, then it will be very easy. But I don't think I should speculate upon it, and I don't think the court should speculate upon it. So that takes me on into the question of the review relief. Now, we submit the primary relief which this court ought to grant is that review relief. It was always part of our case. It is pleaded at paragraph 2.3 of our notice of motion, page 005-4. We ask this court, to the extent that the Minister has taken a final decision in relation to the determination of the date for completion and switch off, that is declared to be unlawful and invalid, and that decision is reviewed and set aside. Now, the Minister initially tried to avoid the impact of the review relief by being coy about whether any final determination had been made. And the answering affidavit is very vague about whether there has been a final determination, whether there hasn't been. But we know, and we said, well, it looks like the President has announced it in SONA. Every public statement that the Minister is putting out there refers to the end of March. The answering affidavit came, it refused to say I've decided the end of March. Lo and behold, a few days before the hearing, we get the gazetted date, and it's the end of March, as we always said. Now, that decision was squarely challenged in the notice of motion. The Minister has been afforded an opportunity to justify that decision. It was in the answering affidavit that she was required to do so if she wanted to do so. And we submit that that decision is plainly unlawful and unconstitutional for the reasons that Mr. Marcus has already given. We agree with our learned friends for ETV that it is irrelevant whether this court construes that decision as one which is administrative in nature or executive in nature. The Minister spends a lot of time trying to show that it is not administrative action. We say that it is, but that even if it isn't, it remains subject to review on the grounds of rationality. And the reference for that proposition, the court will find it in many places, but the one we rely on in particular is Mutau, and I think it's versus the Minister of Defence, in volume 2014, volume 5, SA, page 69, a decision of the Constitutional Court. And what the court held there was that the dismissal of arms corps board members was an executive decision, but that it remains subject to review for rationality. And at paragraph 69 to 71, the court helpfully set out the test for a rationality review, which is whether the decision is rationally related to the purpose for which it was given. And so it remains reviewable on that basis, and I will now move on to my submissions as to why it should be reviewed for lack of rationality. We say really that the decision was plainly irrational for three primary reasons. The first is that there is simply no justification offered for those two decisions I've referred to. Firstly, on the 5th of October to set a 3-week deadline, and secondly, to pick the end of March as the date for cutoff. And what we know is that where a decision is taken and no substantive justification for that decision is offered, what you have is an arbitrary or irrational decision. Again, there's plenty of authority for that proposition, but the one we rely upon is in the case lines bundle at 025-365. It's the New National Party versus the government case, 1999, volume 3, SA 191, Constitutional Court at paragraph 24. Justice Yaqub says, arbitrariness is inconsistent with the rule of law, which is unconstitutional. And so, all of my submissions on the facts have been leading to this point in relation to the failure to justify, in particular, those two decisions. There's just no justification offered. So that's the first reason why we submit the selection of the date is irrational. The second reason is what the court has been debating with me at length, and that is the failure by the minister to conduct any investigation on the impact of the selection of the cut-off date. We've said on the facts that there are 8 million people who will be impacted. What is clear from the answering affidavit is that the minister has never considered how many people are going to be plunged into television darkness. She has not investigated it. The decision has been taken in reliance upon 2018 statistics from the 2018 census. And as a result, the decision was taken in blissful ignorance of its impact on constitutional rights. Now, that we know very well is in itself a ground of irrationality and unconstitutionality. And the case which makes it most plainly apparent is the matter of DA versus the President. It's the Similani case at 2013, Volume 1, SA 248, a decision of the Constitutional Court. Now, if I may just spend a little bit of time on that decision, what happened there is that the President appointed a National Director of Public Prosecutions. That appointment had been criticized by the Ntshvheni Commission, and the review was brought on the basis that the President had failed to take into account relevant considerations, and in particular the findings of the Ntshvheni Commission in relation to the person who was appointed. And what the Constitutional Court held is that even in a rationality review, because that was plainly executive conduct, both the process which was followed and the decision themselves must be rational. The court found that at paragraphs 34 to 37. And at paragraph 39, the court said the following: if in the circumstances of a case there is a failure to take into account relevant material, that failure would constitute part of the means to achieve the purpose for which the power was conferred. And if that failure has an impact on the rationality of the entire process, then the final decision may be rendered irrational and invalid by the irrationality of the process as a whole. That is exactly where we are today. The Minister has failed to investigate, consider, take into account the impact of her decision on the expression rights of South Africans. She's conducted no investigation whatsoever into that issue, and we submit that that failure colours the entire process with irrationality. And so that's the second reason why the irrationality review must be upheld. The third reason, Justices, is to go back to first principles. In a rationality review, one assesses whether the power that has been exercised is rationally related to the purpose for which it was conferred. And what we say in this matter is that when one looks at the Electronic Communications Act and one looks at the digital migration policy, what one finds is that both the Act and the policy seek to chart a course between two important considerations that must both be taken into account under the Act. So firstly, you see from that the power to make policy comes from Section 3, Sub 1 of the Electronic Communications Act, and one then looks at the Electronic Communications Act's purposes to see what purpose that power was given for. And we see that it is important under that Act both to ensure efficient use of radio frequency spectrum, one sees that at Section 2 Sub E of the Act, but also that the Act seeks to ensure that the promotion of the development of public, communal and community broadcasting services, one sees that at Section 2 brackets R, and that the Act seeks to ensure that broadcasting services promote diverse content, news, actuality programs, political issues, matters of international and national significance. One sees that at Section 2 Sub S. And so the Act confers powers in a way that it seeks to serve both purposes, to ensure efficient use of radio spectrum, but also to protect the important public functions of broadcasting services. And so what we submit is that that power cannot be exercised in a way that obliterates the one purpose at the expense of the other. In other words, it cannot be exercised in a way that obliterates the public value of broadcasting services in order to ensure efficient helpful use of radio spectrum by network operators. It must, in order to be exercised lawfully in accordance with the purpose of the Act, it must strike a balance between those two interests, because there are both interests that are legitimately recognized by the Act, and that is carried through in the digital migration policy. The court doesn't need to go there, but it's at page 001-261. That policy recognizes both of these important purposes. It recognizes the benefits of what it calls the digital dividend, but it also states that those benefits must be realized without losing access on the part of millions who rely on free-to-air television for information. So both of those purposes have to be taken into account, and unfortunately the way that the Minister has exercised this power, the effect is to obliterate the value of free-to-air broadcasting in the hands of the indigent in order to ensure a speedy spectrum auction. And we said that that is not permissible, and that too is irrational. Justices, I'm not going to repeat any of Mr. Marcus's submissions in relation to expression, only to add to what he said. The only point we would make is that in addition to the fact that this was a policy decision which cannot lawfully limit fundamental rights, it is also a decision which is retrogressive in the sense that it removes existing access to expression rights and fails to respect existing protections of access to expression. And for that reason too, in terms of the Khumbudzo decision and the Juma Musjid decision of the Constitutional Court, it's a breach of the duty not to impair existing access to fundamental rights, and so it requires justification at the very least, and none of that has been done because of what we've said about the failure to offer a substantive justification. So Justices, very briefly, what do we get in defence? Well, as I've said, no respondent gives us any reason why the end of March rather than the end of April or May or June or July. No respondent says why it was necessary on the 5th of October to create this 3-week deadline. And the Minister in particular says very little about that. What we're left with really is the attempt by Vodacom to characterize this as a policy choice between cheaper access to Vodacom's services through cheaper data on the one hand, and what it calls cheaper access to ETV's free-to-air television broadcasts on the other hand. Now, that is simply a fundamental mischaracterization. And Vodacom says that's the policy choice which the Minister has made and which the Minister was permitted to make. That is a mischaracterization of this case, because what it fails to take into account is the following. Firstly, that these are indigent families that we are referring to who currently enjoy free access to ETV services. And so it is a removal of that currently existing free access which is sought to be justified, and which has not been justified. It's not a question of cheaper access to one versus cheaper access to the other. That's the whole point of the retrogressive measure, that it takes away something which already exists, and it already exists for free through the mechanism of free-to-air television. Secondly, it's not for Vodacom to tell us what policy choice the Minister has made. That's not what the Minister says is the policy choice that she has made. She says, on the contrary, she intends to bring everyone along in this digital migration. So really, for Vodacom to seek to justify the policy on a basis totally inconsistent with that made out by the Minister is just unsustainable. And then finally from Vodacom, we get this submission, well, let me know, Mr. Marcus has already addressed the question of the bottleneck and the inertia, where Vodacom submits that it's inertia on behalf of indigent households which has resulted in the bottleneck. Let me just say that there is simply no evidentiary basis for that speculation contained in paragraph 10 of Vodacom's heads. It is pure speculation from the corporate suite, which simply cannot justify a violation of a fundamental right of this nature. So there's really no proper defense to the review relief. And what we submit is that places the review relief beyond any question.
Mr. Ferreira, can I just ask, and obviously this makes all sorts of assumptions about effective installation and that we're actually reaching the right people, etc., etc. But would your clients accept that a government-free subsidized, so free to your hands, set-top box installed is the equivalent of free-to-air analog TV. So if government could get a box into your house in time, you would accept that that is the equivalent of free-to-air analog.
Yes, and in some ways better, because there's more channels available and the quality is better and so on. So yes, absolutely, we would accept that.
And Mr. Pereira, insofar as the investigation, an assessment, a study of establishing exactly what the de facto position is out there. Is there such an assessment? Can such an assessment or study be undertaken? Is it when we look at maybe the broadcasting association looking to exactly which houses get analog, which ones get digital, because now we've got the simulcast position where there's both analog and digital. Is it feasible to get an assessment, a study that will actually be able to say what the actual position is? Is there anything like it? Can that be undertaken?
Justice Msimang, I think I would be speculating from the bar if I were to try to answer that, but what I can tell you is that there are entities in South Africa whose very reason for existence is to undertake that sort of statistical analysis. The primary amongst them is the Broadcast Research Council, whose evidence I referred to at the outset. And that sort of statistical information about who watches which programs on which channels is most certainly something which is very common throughout the media industry, and it's used as a basis, for example, to sell advertising, to target marketing, and so on. So yes, it is certainly possible, and we submit the best evidence on the papers is the one in paragraph 62 of our founding affidavit, those statistics which are provided by the Broadcast Research Council. Justices, that leaves the declaratory relief. We continue to ask for that declaratory relief in prayers 2.1 and 2.2 of the Notice of Motion. We submit those prayers are appropriate, just and equitable relief in addition to the review relief. But just to preempt some of what I think is coming from our learned friends, it's these prayers which gets their hackles up about being interdict disguised as a declarator, and which they say implicates the outer decision, which requires a very high standard, a very good case to be made out in order to avoid separation of powers, harms, and so on. We say those submissions ought not to weigh heavily with this court, but if they do, then there's no difficulty if this court simply grants the review relief and decides not to grant the declaratory relief. The review relief would constitute effective, just and equitable relief in the hands of MMA and SMS, and provided that the reasons given make clear why the determination of the switch-off date was unlawful, my clients would have no difficulty with the review relief standing without the declaratory relief. But we do say that this is a case like in rail commuters, where the minister seems not to understand the content of her constitutional obligations, and where declaratory relief of that kind, in order to inform her of what she is obliged to do to conduct a lawful process, would be helpful. And as Mr. Marcus has submitted, the state has denied that it has those duties, and so we submit it is appropriate and just and equitable to grant the declaratory relief. And we have nothing to add to what Mr. Marcus said about the reporting relief, other than to say it's rather ironic that Mr. Mutau, who bridles so at the duty to report to this court, is going to ask this court's indulgence in 5 minutes' time to do precisely that. In other words, to update this court as to the status of this ongoing installation project and how far the minister has gone. Why there should be such an objection to continuing to do so after this court's order, we simply don't understand. And so we say it's quite, and Justice Leroux, to answer the question that you put to Mr. Marcus, to grant that reporting relief is not to put the court in a position of managing the process or determining how it should unfold, because all it requires the minister to do is file an affidavit from time to time explaining what has been done, and it would then be for the applicants, should they seek any further relief arising out of those reports, to come to court to ask for it to be granted. We know in practice that courts would not even really read those reports as they come in. It would simply go as a matter into the court file, and it is then in our adversarial system for the applicants to decide how to respond to it and whether to rely upon it in seeking any further consequential relief. So we submit it would be appropriate to grant that relief. My final submission is on the issue of costs. We seek only the costs of 2 counsel where so employed in the event that we are successful. We submit that if we are unsuccessful on BioWatch, because this is public interest litigation in which relief is sought only against the state, that no costs order should be awarded against my clients. That is the have your cake and eat it rule established by BioWatch. And we submit that in relation to Vodacom, again, no relief was sought specifically against Vodacom. So even if my clients are unsuccessful, they should not be paying Vodacom's costs, because Vodacom made an election to come to court to defend a commercial interest against a public attack on a decision taken by a different entity. And so there's no basis for Vodacom to have costs, even if we don't succeed. Justices, if I may just have a moment, I happen to be stranded in Cape Town due to the British Airways debacle, so if I may just have one moment to consult with my team up in Joburg to see if I've missed anything, I'd be grateful.
It's fine.
Justices, there's just one clarificatory point which I should make clear. If this debate is characterized as one about access to ETV as opposed to all terrestrial television, that's an inaccurate characterization. I may have misspoken in characterizing it that way. It is about all free-to-air television broadcasts, which for which the indigent households are currently reliant upon free-to-air broadcasts. Not just a question of ETV.
Sorry, and Mr. Ferreira, just because we got Mr. Marcus's position, your clients would accept that the 5 provinces that are switched off stay switched off?
Yes, none of the relief that we have sought seeks to undo that existing status quo, my lady. Thank you, Justice.
Thank you, Mr. Ferreira. I see it's now 4 o'clock. And my sister Bukaimani has got some engagement at 4, so it means that we just have to adjourn until what time tomorrow? 10 o'clock? My sisters?
Yes, I'm happy with 10 o'clock, and also tomorrow I'm happy that we can proceed until we finish. If we run over time, I think we should.
I'm sorry?
Because we certainly are, we thought we would have heard from Mr. Matau by now, although the debate was very useful. I suppose we can always shorten the lunch adjournment.
Yes.
Start at 10, shorten lunch possibly, and possibly have to sit a little late to get it all done.
Yes.
But I'm sure everyone who will come tomorrow will have benefited from the debate of today and will be very targeted, I'm sure.
Okay, thank you.
David will help us.
Yeah, we'll wait for that affidavit. I suppose it will be posted. Then the court will adjourn until tomorrow 10 o'clock.
I wonder whether our learned friend for the minister could give us an update on the status of the affidavit.
Mr. Matau, are you with her?
Yes, thank you, Justice Marcus. Can I do the following, perhaps? Can I, because I've been sitting in here, get the first opportunity to speak to my clients, and I'll reach out to yourself and Nick and Frank.
Thank you, my lord.
Okay,
Thank you.
thank you. Then the court will adjourn until tomorrow 10 o'clock. Thank you.
Thank you. Bye.